Section 32 of Tribal Custom in Anglo-Saxon Law. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Read by Kristen Hand. Tribal Custom in Anglo-Saxon Law by Frederic Seebohm. Chapter 14, The Laws of the Kentish Kings, Part 1. 1. Distinction from Anglo-Saxon laws, AD 596 to 696. The laws of the Kentish kings, if they had been on all fours with the other Anglo-Saxon laws, would have taken back the general evidence for Anglo-Saxon custom another 100 years earlier than the laws of Ine, and nearer the time of the conquest of Britain. As it is, however, they have to be treated as in part exceptional. It is very probable that for a long period the proximity of Kent to the continent had resulted in the approximation of its social and economic conditions to those of the opposite shore of the Channel. The southeast corner of Britain was described by Caesar as having been colonized by Belgae and as having been for some time under Belgic rule. The Belgic tribes were the furthest advance of Celtic tribes and, according to Caesar, had fostered agriculture, while his informants spoke of the interior of Britain as pastoral. Under Roman rule, the prominence of agriculture was continued. Ammianus Marcellinus describes large exports of British corn to supply Roman legions on the Rhine. He speaks of the British tributary in a way which suggests that this part of Britain under Roman rule had become subject to economic arrangements similar to those of the Belgic provinces of Gaul. The introduction, by invitation, of the Jutes into Kent and their settlement, in the first instance at all events, under a friendly agreement of payment of annaune, may have given an exceptional character to the results of ultimate conquest. The permanent prominence of agriculture is perhaps shown by the fiscal assessment in salungs and yokes instead of hides and virgats. The exceptional conditions of the Kentish district were continued by its being the earliest to come into close contact with the court of the Merovingian Franks and with ecclesiastical influences from Rome. The mission of St. Augustine resulted in the codification of Kentish custom into written law a century earlier than the date of the earliest laws of Wessex. The peculiar character of Kentish custom may have been further maintained by the partial isolation of Kent. The kingdom of the Kentish kings, though lessened in Ethelbert's time by the encroachment of Wessex, had maintained its independence of both the Northumbrian and Mercian supremacy, or Bretwaldership. Apart from any original difference in custom between Jutish and other tribes, this isolation naturally produced divergence in some respects from the customs of the rest of Anglo-Saxon England, and may perhaps partly explain why the laws of the Kentish kings came to be included in only one of the early collections of Anglo-Saxon laws. Further, when we approach the subject of Kentish weregelds, we do so with the direct warning, already alluded to, of the writer of the so-called Laws of Henry I, that we shall find them differing greatly from those of Wessex. This we have said according to our law and custom, but the difference of weregeld is great in Kent, villanorum et baronum. Moreover, in after times, Kentish custom differed from that of other parts of England in the matter of succession. The custom of gavelkind prevailed in Kent, and among the statutes after the Norman conquest, there is an undated statement setting forth peculiar customs of Kent in matters where they differed from those of the rest of the kingdom. Some of these differences may have been of later origin, but a comparison of the laws themselves with other Anglo-Saxon laws is conclusive upon the point that important differences always existed, and what is more, were recognized as existing. Although the Kentish laws are not included with other Anglo-Saxon laws in any manuscript but that of Rochester, yet they were known to King Alfred. He mentioned them in the proem to his laws, as well as the Mercian laws, as among those which he had before him in framing his own. Moreover, we have seen that at the time of the Danish invasion, certain differences between the Kentish and other laws were known and noted correctly in the fragment of Girth and of Mund. Finally, in its system of monetary reckoning, the Kentish kingdom seems to have been peculiar from the first. And as our knowledge of the Kentish weregelds is essential to an understanding of the division of classes, a good deal must depend upon a previous understanding of the currency in which the amounts of the weregelds were described. Before proceeding further, it is necessary, therefore, to devote a section to a careful consideration of the subject. The experience already gained will not be thrown away if it should help us to understand the meaning of the scaets and skillings of the Kentish laws. 2. The scaets and skillings of the Kentish laws. All the payments mentioned in the Kentish laws are stated in scaets and skillings, naturally by far the larger number of them in the latter. What were these scaets and skillings? First, what were the scaets? We have already seen that before the time of Offa, the silver coinage current in England consisted mainly of the silver tremises of Merovingian standard, i.e., 20 to the Roman ounce, or 28.8 wheat grains. These are known to numismatists as silver pence of the scaet series. That these silver coins were known by the name of scaets, we seem to have the direct and independent evidence of the following fragment on Mercian law, already quoted but sufficiently important to be repeated here. Corles Vergeld is on Mycia large cc skill. Pegnes Vergeld is 6 swa Michael, payet bio 12 hund skill. Pon bio signes Eifeld Vergeld 6 pegna ver bei Myrina laga payet s xxx pusend skeata and payet bio Elias cxx punda. The Corles Vergeld is in the law of the Mercians 200 skillings. The Thanes Vergeld is 6 times as much, i.e., 1,200 skillings. Then is the King's simple Vergeld 6 Thanes Vergeld by Mercian law, i.e., 30,000 scaets, and that is in all 120 pounds. Now, as previously observed, the sum of 30,000 scaets must evidently be taken as a round sum. The statement that the King's simple Vergeld was 120 pounds, or 6 times the Thanes Vergeld of 1,200 Mercian skillings, seems to make this clear, for 7,200 Mercian skillings of 4 scaets, 28,800 scaets, would amount exactly to 120 pounds. That the scaets of this fragment of Mercian law were the same silver coins as the scaets of the Kentish laws is further confirmed by numismatic evidence. The evidence of the coins themselves and of the names of the moneyers impressed on them seems to make it probable that to a large extent till the time of Egbert, who was intimate with Charlemagne, and perhaps even till the time of his grandson Ethelbald, in the words of Mr. Carey, Kent still provided all the currency of the South. It would seem, therefore, that practically during the whole period of the issue of the silver pence of the scaet series, the greater part of them were minted by Kentish moneyers. And thus numismatic evidence applies not only to the coinage of Wessex, but also to that of Mercia. We can hardly be wrong, then, in thinking that this valuable fragment of Mercian law in using the word scaet referred back to an ancient custom before the scaet had been superseded by the penny, and therefore must be good evidence that the silver coins called scaets in Mercia were similar to those called scaets in Kent. In other words, the Kentish scaet, notwithstanding the slight difference in spelling, was almost certainly the silver scaet of 28.8 wheat grains, i.e., 20 to the Roman ounce. It is quite true that the word scaet was used in the laws in 2 senses, sometimes for money or property, and sometimes for the coin. But so also was the scaet of the Kentish laws, and it may not always be easy to ascertain with certainty which meaning is the right one. But the Kentish and Mercian laws were not alone in using the word for the silver coin. The phrase scaets and skillings was elsewhere used to denote the typical smaller and larger monetary unit, or perhaps we ought to say the silver and the gold unit. In the 10th century translation of the New Testament, the word denarius is translated by peaning. For long before this, the penny of 32 wheat grains had superseded the old coinage of the scaet series. but in the translation of Ulfilas, the word scat is used for the silver denarius. At the same time, it is important to observe that the word skilling was the Gothic word applied to the gold solidus in legal documents of the 6th century during Gothic rule in Italy. According to the bilingual records in the archives of the Gothic Church of St. Anastasia at Ravenna, payments were made in so many skilligans. So that probably silver scats and certainly gold skillings were familiar to the Goths of Italy. Again, scaats and skillings were evidently the two monetary units familiar to the mind of Caedmon or whoever was the author of the metrical translation of Genesis. In chapter 14, verse 23, Abraham is made to swear that he would take neither scaat ne skilling from the kingdom of Sodom. Moreover, in the fragment on oaths in the Anglo-Saxon laws, Thorpe, page 76, the same phrase is used. On lefendis gods nemen, ne orif ik ne scat ne skilling, ne paying ne paynage veard. S11. In the name of the living God, I owe not to n scat or skilling, not penny or penny's worth. Surely in both phrases, the phrase scat ne skilling refers to coins or units of account of two denominations in current use, as in the Kentish laws. It is even possible, perhaps, to find an illustration of the reckoning in scaats and skillings in the well-known passage in the Skald's Tale already quoted. Se me beag forgif, on them 600 vees, smeets golds, gescried scaata skilling rhyme. He me a bracelet gave, on which 600 was of beaten gold, scored of scaats in skillings reckoned. If these words may be properly translated literally, of scaats in skillings reckoned, and are taken to mean 600 scaats in skillings reckoned, the phrase accords very closely with the method of reckoning in the Salic laws, so many hundred denarii, i.e., so many solidi. Returning to the scaats and skillings of the laws of Ethelbert, the most obvious suggestion would be that the currency in Kent was similar to that on the other side of the Channel under the Merovingian princes. The two courts were so closely connected by Ethelbert's marriage, and probably by trade intercourse, that the most likely guess, at first sight, would be that the Kentish scaats were silver tremises, and the Kentish skillings gold solidi, like those of the Lex Salica. We have seen that the Merovingian currency was mainly in gold tremises, and as many of the 100 gold tremises contained in the celebrated Crondale find are believed by numismatists to have been coined in Kent by English moneyers. The currency of gold tremises in England is directly confirmed, though the silver currency seems very soon to have superseded it. At the date of Ethelbert's laws, A.D. 596, the Merovingian currency was still mainly gold, i.e. gold tremises, 3 of which went to the gold solidus of the Salic laws. And if the skilling of Ethelbert, like the solidus of the Franks, had been a solidus of 40 denarii, we might have concluded at once that Ethelbert's skilling, like the Merovingian solidus, was a solidus of 3 gold tremises, or 40 silver scaats. But the facts apparently will not allow us to come to this conclusion. Schmid has shown, I think conclusively, by inference from certain passages in Ethelbert's laws, that the Kentish skilling was of 20 scaats instead of 40. We therefore must deal with the Kentish skilling on its own evidence. Now, 20 scaats of 28.8 wheat grains, as we have seen, made the Roman ounce of 576 wheat grains. The Kentish skilling was therefore the equivalent of an ounce of silver. And so in the Kentish laws, so far as reckoning in silver was concerned, the same method was adopted as that of the Welsh, who reckoned in scores or unisae of silver, and that which became the common Frankish and Norman reckoning of 20 pence to the ounce and 12 ounces to the pound. Indeed, when we consider that under common Scandinavian custom, gold and silver were weighed and reckoned in marks, oars, and oartugs, it would seem natural that the Kentish immigrants from the north should have been already familiar with a reckoning in oars or ounces of silver. But why did they call the ounce of silver a skilling? We might as well perhaps ask why the Wessex skilling was 5 pence and the Mercian skilling 4 pence. But the word skilling had, as we have seen, been used by the Goths in Italy for the gold solidus, and on the continent the gold solidus in the 6th and 7th centuries, and indeed till the time of Charlemagne, was so far the recognized symbol of value that the Wehrgelds of the northern tribes, whether they remained in the north or emigrated southwards, were invariably stated in their laws in gold solidi. The most natural inference would therefore seem to be that the Kentish skilling, like that of the Salic law, must have been a gold solidus equated, however, in account with 20 silver pence or scaeads. Now, at the ratio of 1 to 10, the ore or ounce of 20 silver scaeads would equal a gold solidus of 2 gold tremises instead of 3. And when it is considered that the main Merovingian currency on the other side of the channel was of gold tremises, it seems natural that the ounce of silver should be equated with an even number of gold tremises. Nor would there be anything unprecedented or unusual in a gold solidus of 2 tremises instead of 3. For we have seen that when Charlemagne conquered the Frisians and the Saxons, he found that the solidi in which they had traditionally paid their Wehrgelds were not always, like the imperial and the Salic solidi, of 3 gold tremises, but that each district had its own peculiar solidus. The solidus of the southern division of Frisia was of 2.5 gold tremises. The solidus of the middle district was the ordinary gold solidus of 3 tremises. The traditional solidus of the district presumably nearest to the Jutes, i.e. on both the Frisian and Saxon side of the Weser, was the solidus of 2 tremises. The Saxon solidus of 2 tremises, representing the 1-year-old bullock, was that in which, according to the Lex Saxonum, the Saxon Wehrgelds had been traditionally paid. We have no distinct mention of a Jutish solidus, but as the Jutes probably came from a district not far from that of the North Frisians and Saxons, there would be nothing abnormal or surprising in their reckoning in the same solidus as their neighbors, viz., in the gold solidus of 2 tremises, and in the Kentish immigrants continuing the same practice. But this as yet is only conjecture. So far, then, as the facts of the prevalent coinage and currency are concerned, all that can be said is that the hypothesis that the Kentish skilling was that of 2 gold tremises has a good deal of probability in its favor. But there is other and more direct evidence of the truth of the hypothesis. In the first place, as already stated, in the preface to King Alfred's laws, he expressly mentions his knowledge of the laws, not only of Ein and of Offa, but also of Ethelbert, the inference being that in his own laws he retained inter alia some of the enactments of Ethelbert which were in his own view worth retaining. Now King Alfred fixed the king's mundberd at 5 pounds of silver, i.e. 240 Wessex skillings, while he must have known that in the Kentish law the king's mundberg was 50 Kentish skillings. The difference in skillings must have struck him, but he probably knew perfectly well what the Kentish skillings were. For when we compare these 2 mundberds, we find that at a ratio between gold and silver of 1 to 12, which, as we have seen, was the Frankish ratio of Charlemagne's successors, 50 Kentish skillings of 2 gold tremises did equal exactly 5 pounds. 50 Kentish skillings, or 100 Merovingian gold tremises, at 1 to 20 were equal to 1,200 silver tremises, or scaeads of the same weight, i.e. 5 pounds of 240 scaeads, or in other words, 100 gold tremises, nova moneta, were equal at the same ratio to 5 pounds of 240 of King Alfred's pence of 32 wheat grains. The equation was exact. And further, we have seen that in the time of Knut, the Kentish king's mundberd was well known and declared to be 5 pounds according to Kentish law, although in that law it was stated to be 50 skillings. The passage has already been quoted from the MSG of Knut's Church Law, S3, in which, after stating that the girth Bryce of the chief minister in cases entitled to bot is according to the king's mund, that is, 5 pounds by English law. The additional information is inserted. On Kent land et pam mund Bryce 5 pund pam king. In Kent land for the Mundbreis, £5 to the king. Further, in the same MSG of Newt's Secular Law S63 is the following. Give hwa ham son ge vers ge bet p mid 5 punden pam sink on engla lag 7 on cent et ham son 5 pam sink 7 preo pam arc biscope 7 dina lag swa hit erstud 7 gif hein mon par affili likey agild. If anyone commits hamscon, let him make bot for it with £5 to the king by English law, and in Kent from hamscon 5 to the king and 3 to the archbishop, and by Danish law as it formerly stood, if he there be killed, let him lie unpaid for. It is not very clear what the hamscon was. In the Latin versions, it is translated by invasio domi, and it seems to be the same thing as the heimskon of Norse laws. It seemed to be a breach of the peace within the sacred precinct of the Heim, and the penalty seems to place it on the same ground as the Borbreis and Munbird of the king, so as to have become in Newt's time one of the crimes in which Kent also involved a penalty of 50 Kentish skillings. Here then, the inference again is that 50 Kentish skillings were equal in Newt's time to £5 of silver. It is quite true that these two statements of Kentish law are not found in the other manuscripts of Newt's laws, so that in one sense they may be regarded as interpolations, but in the MSG they are not insertions made afterwards. In both passages, the words form an integral part of the text, which throughout is written in a clear and excellent hand. It is difficult to suggest any reason for the insertion of these two statements of Kentish law other than the deliberate intention to point out that the amount of the Kentish king's mundbird of 50 Kentish skillings was the same as the Wessex mundbird of £5 of silver. In addition, therefore, to the fact that at a ratio of 1 to 12 between gold and silver, the two amounts were alike, these passages seem to show that the penalty of 50 Kentish skillings had been permanently recognized in Newt's time as equal to the English penalty of £5 of silver. If the comparison had been made throughout in silver scates, the equation would not have held good so exactly, for 1,000 scates would not have equaled exactly £5, i.e. 1,200 of the same scates. The exact equation seems to have been between 50 Kentish gold skillings of 2 tremises and £5 of silver at the current Frankish ratio of 1 to 12. So that the direct evidence of these passages from Newt's laws goes very far to verify the hypothesis derived from numismatic considerations that the skilling of the Kentish laws was a gold skilling of 2 tremises, like that of the continental Saxons and northeast Frisians. It is, however, only fair to say that Schmid, while adhering to the view that the Kentish skilling was of 20 scates, has suggested that these scates may have been not silver tremises or pence, but farthings, so that the Kentish skilling of 20 farthings might be identical with the Wessex skillings of 5d. Conrad von Maurer held the same view. But if this could be supposed for a moment, the Kentish scate would then be only 1/4 of the scate of the fragment of Mercian law, and the mundbird of King Ethelbert would be only 1/4 of that of the Wessex king, notwithstanding the assertion in MSG of the laws of Newt that the Kentish mundbird was £5 of silver, like those of other English laws. With all deference, therefore, to the view of these great authorities, a careful examination of the evidence seems to lead to the conclusion that it cannot be maintained. Nor does there appear to be any reason why the Kentish skilling should be expected to be the same as the Wessex skilling, as we know that the Wessex skilling of 5d differed from the Mercian skilling of 4d. We adhere then to the view that the Kentish skilling was a skilling of 2 gold tremises, like the Saxon solidus, and that it was equated with the or Roman ounce of silver, i.e. 20 scates. The reader will be able to form his own judgment as to whether examination of the various clauses of the Kentish laws and the amount of the varigolds and other payments now to be considered will confirm this conclusion or not. I think it will be found substantially to do so. End of section 32. Section 33 of Tribal Custom in Anglo-Saxon Law. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Read by Kristen Hand. Tribal Custom in Anglo-Saxon Law by Frederic Seebohm. Chapter 14. The Laws of the Kentish Kings, Part 2. 3. The Laws of Ethelbert. The Laws of Ethelbert begin with the heading, "These are the dooms which King Ethelbert established in the days of Augustine." This heading probably did not form a part of the original laws, but it may serve to remind us that ecclesiastical influence must be reckoned with in their consideration, and that some of their clauses may have been modifications of ancient custom rather than statements of what it originally was. The first clause is as follows. Gades feo 7 Circean 12 Guild. The property of God and of the Church 12-fold. Bishops feo 11 Guild. A bishop's 12-fold. Praeosts feo 9 Guild. A priest's 9-fold. Diacones feo 6 Guild. A deacon's 6-fold. Clerks feo 3 Guild. A clerk's 3-fold. Cyric frio 2 Guild. Church frith 2-fold. Maple frio 2 Guild. Moot frith 2-fold. This clause is read by Thorpe and Schmid and Lieberman as enacting that thefts were to be paid for on this scale, so many multiples of the value of the goods stolen. Clause 2 enacts, give Kyning his leod to him Gehetio, 7 heum mon per Eifelgedo, 2 bot, 7 signi, 50 skillinga. If the king call his leod to him, and any one there do them evil, the bot is 2-fold and 50 skillings to the king. Here are two distinct things. The bot is the payment to the person called to the king. While thus in attendance, any injury is to be paid for 2-fold. The payment of 50 skillings to the king is the mundbeard, or payment for breach of his protection or peace. Clause 3 is as follows. Give Kyning 8 manes ham drinkeo, 7 per man lesues, hoet gedo twi bot gebet. If the king drink at anyone's ham, and anyone there does something wrong, then let him pay 2-fold bot. That is, the presence of the king at a subject's house is the same as the subject being in the king's protection, and the bot for any wrong done to the subject while the king is there is doubled. Clause 4 enacts, give Frigman signi stel 9 Guild for Guild. If a freeman steal from the king, let him pay 9-fold. It seems at first sight hardly likely that the archbishop should be compensated 11-fold and the king only 9-fold, but as this is repeated in the statement of the Kentish law in the fragment of Girth and of Mund, the text may be taken as correct. Clause 5 enacts, Gif in signes tun man manna of slaya 50 skill gebet. If a man slay another in the king's tune, let him make bot with 50 skillings. The bot here again is evidently the mundbeard payable to the king for breach of his protection, i.e. 50 Kentish skillings. Clause 6 enacts, Gif man frigni manen of sleo signe 50 skilling to Drichten beg. If anyone slay a free man, 50 skillings to the king as Drichten beg. Here again the payment is to the king, but in this case, if the word is to be taken literally, it is not perhaps for breach of his peace, but for the killing of his man. He claims it as his Drichten beg, or Lord's ring. It is, to use the later Saxon phrase, the king's man-bot, or value to him of his man killed. Up to this point, the question of Vergeld has not been mentioned at all, but in Clause 7 is the following. Give signes ambit smeo ape ladrink manen afsleo, Medumen leedgeld voorgeld. If the king's ambit smith, official smith, or a ladrink, outrider, slay a man, let him pay a medumen leodgeld. Lieberman would insert the word man after gif, and so read this clause as stating the vergeld of the king's smith and the ladrink man, when slain, to be a medum vergeld, mittleres vergeld. But the clause is complete as it stands without the insertion of man, and read as it is means that the smith and the outriders of the king, if they slay a man, are to pay a medum leodgeld. But what does this mean? The word medum was translated by Wilkins by Moderata. Thorpe read the phrase as meaning a half vergeld, Schmid as a fit and proper one, and Lieberman would take it to refer to the vergeld of a person of middle rank or position. We must leave the true meaning for the present in doubt. Apart from the amount of the vergeld, if we would understand this passage, we would have surely first to consider for what reason these two royal officials should be singled out from all others and made liable to pay vergelds. The inference must be that in the performance of their duties, they were peculiarly liable to injure others. The king's smith in his smithy forging a weapon, and the outrider forcing a way for the king through a crowd, might very easily, through carelessness or in the excitement of work, cause the death of another. The necessity apparently had arisen to check their action by making them liable to pay a vergeld, but the vergeld was not to be the usual one. It was to be a medum leodgeld. For the present, the exact meaning may be left open, but whether the true reading be a half vergeld or not, the inference seems to be that a full vergeld was not to be paid. Perhaps it had come to be recognized that a person engaged in a specially dangerous trade could not be held responsible to the same extent as in the case of an ordinary homicide. These considerations are important because the medum vergeld will again claim notice, and every hint is valuable when, as in the case of these laws, we have only hints to guide us. In Clause 8, the king's mundbird is declared to be 50 skillings, and the next two clauses relate to injuries done to the king's servants. Gif men viosinges magden men gelegio 50 skilling gebet. 10. If anyone lie with a king's maiden, let him pay a bot of 50 skillings. Gif hio grindende peo sio 25 skilling gebet. Sio pride 12 skillings. 11. If she be a grinding slave, let him pay a bot of 25 skillings. The third class, 12 skillings. Signes fedessel 20 skillinga vergeld. 12. Let the king's fedessel be paid for with 20 skillings. These bots are evidently payable to the king for injuries done to him by abuse of his servants of different grades. They were not vergelds. We have now done with these bots to the king, and the laws turn to consider injuries done and bots due to the earl. Gif on earls tun man mannen afsleho 12 skilling gebet. 13. If a man slay another in an earl's ton, let him make bot with 12 skillings. Gif weo earls berle man gelegio 12 skillings gebet. 14. If a man lie with an earl's berle, let him make bot with 12 skillings. And then from the bots due to the earl, the laws pass to those due to the curl. The following clauses show that under the Kentish laws, the curl also had a mundbeard. Curl's mundbeard, 6 skillingas. 15. A curl's mundbeard, 6 skillings. Gif weo curls berlan, man gelegio, 6 skillingum gebet. Et per oer peoen, 50 skeda. Et per pridden 30 skeda. 16. If a man lie with a curl's berle, let him make bot with 6 skillings. If with the slave of the second class, 50 skaets. If with one of the third class, 30 skaets. Thus we get a scale of mundbirds, or penalties due for breach of the peace or protection of the king, the earl, and the curl. King's Mundbird, 50 skillings. Earl's Mundbird, 12 skillings. Curl's Mundbird, 6 skillings. But so far, we have learned nothing about the amount of their Wehrgelds. Clause 17 fixes the bot for inroad into a man's ton at 6 skillings for the first person entering, 3 for the next, and 1 for the rest. Then follow an interesting set of clauses, which I think must be read together, as all referring to the case of what might happen in a brawl in which one man lends a weapon to another. Gif man mannen weaponum, bei berep or seus, weerd 7 man naning, effel nan gedep, 6 skillingum gebet. 18. If a man furnishes weapons to another where there is strife, and the man does no harm, let him make bot with 6 skillings. Gif wegrief sei gedan, 6 skillingum gebet. 19. If wegrief, street robbery, be done, let him make bot with 6 skillings. Gif men pone men of sleo, 20 skillingum gebet. 20. If anyone slay that man, i.e., to whom he lent the weapons, let him, the lender, make bot with 20 skillings. Gif men memen of sleo medum leodgild, 100 skillinga gebet. 21. If a man slay another, let him, the lender, make bot with a medum leodgeld of 100 skillings. Gif man mannen of sleho, et openum geref, 20 skillinga for geld 7, in 40 nita elne leod for geld. 22. If a man slay another, let him at the open grave pay 20 skillings, and in 40 nights pay a full leod. Gif bana of land gewetep pamagas, helfne leod for gelden. 23. If the slayer depart from the land, let his kindred pay a half leod. These clauses, taken together and followed carefully, I think, become intelligible. A man lends weapons to another who is engaged in a brawl, and the question arises how far he is to be responsible for what happens in the brawl. In the case dealt with in these clauses, 2 things are involved: the lending of the weapons and the joining thereby in the fray. In the later laws, there are provisions for both points. Under King Alfred's laws, S19, the man who lends his weapon to another who kills someone therewith has to pay at least 1/3 of the Wehrgeld, unless he can clear himself from evil intention. Under Ein's laws, S34, a man who joins in the fray in which someone is killed, even if he can clear himself from the slaying, has to pay as bot, gebet, 1/4 of the Wehrgeld of the slain person, whether twihind or dearer born. Under Alfred, 29-31, the actual slayer has to pay the Wehrgeld, and in addition, each of the others in the fray has to pay as hulubot, 30 skillings for a twihind man, 60 for a 6hind, and 120 for a 12hind man. These later precedents may materially help us in understanding of the Kentish clauses. Clauses 18 and 19 make the lender of the weapon pay a bot of 6 skillings, though no evil be done or only street robbery occur. Clause 20 provides for the case in which the man to whom he lent the weapon was slain, and in this case the bot is raised to 20 skillings. Clause 21 seems to deal with the case of someone else being slain and makes the lender liable to pay a bot of a medum leodgild of 100 skillings for mixing in the fray. It would be natural that the bot should be greater if another was slain than if the man to whom he lent the weapons had been slain. And if the later precedents are to guide us, the bot of a medum Wehrgeld should not in amount equal the whole Wehrgeld, but only a proportion of the Wehrgeld. If the bot of 100 skillings might be considered as equal to a half Wehrgeld, we should gain a clue to what the whole Wehrgeld might be. And this would be a tempting inference, but we are not, it seems, as yet warranted in making it. We must therefore at present content ourselves with the conclusion that the medum Wehrgeld cannot mean a whole Wehrgeld, Otherwise, the lender of the weapon would pay as bot as much as the Vergeld would be if he had killed the man himself. Clause 22 makes 20 skillings payable at the open grave and the whole liad in 40 nights. It refers apparently to the actual slayer's liability to pay the whole Vergeld, eln liad, and finally Clause 23 states that if the slayer depart from the land, his kindred shall pay half the Vergeld of the slain person. We are not told to whom the bot of the Medum Vergeld of 100 skillings was to be paid, nor whether it was to be a part of the Vergeld or additional to the elne liad paid by the actual slayer. The later laws, as we have seen, afford precedence for both alternatives. Another point of interest arises from the last clause. In the absence of the slayer, his kindred had to pay only a half Vergeld, helfni liad. Does this justify the inference that in all cases of Vergelds, the liability of the kindred was confined to one half? It will be remembered that in the so-called Canons Vallici, supra, page 109, if the slayer had fled, the parentes of the slayer had 15 days allowed for their payment of one half or flight from the country. And only when they had paid their share could the slayer return and make himself safe by paying the other half, the medium quat restat. It seems not unlikely that in the Kentish case, also ecclesiastical influence had limited the liability of the kindred to the half Vergeld. Clauses 25 and 26 are important, and we shall have to recur to them. Gif man Corleas hlaf eten of sleho, 6 skillingum gebet. 25. If anyone slay a coros halfleita, let him make bot with 6 skillings. Gif leet of sleho pone celestan 80 skillings for gelda. Gif pane oderne of sleho 60 skillingum for gelde. Pain pridden 40 skillingum for gelden. 26. If anyone slay a leet of the best class, let him pay 80 skillings. Of one of the second, let him pay 60 skillings. Of the third, let him pay 40 skillings. To these 3 grades of leets we shall have to return when we sum up the evidence on the division of classes. Next follow 3 clauses upon Edor breach. The first relates to the breach by a freeman of the enclosure or precinct, presumably of a freeman, the penalty being the same as the quarrels mund. The second imposes a 3-fold bot upon theft from within the precinct, and the third refers to a freeman's trespass over the edor or fence. Give freeman edor broach, gedeo 6 skillingum gebet. 27. If a freeman commit edor breach, let him make bot with 6 skillings. Gif man in a feo ginemeo, say man 3 gelde gebet. 28. If anyone take property, cattle, from within, let him pay a 3-fold bot. Gif freeman edor gengangio 4 skillingum gebet. 29. If a freeman trespass over a fence, let him make bot with 4 skillings. After these clauses about edor breach is the following. Gif man mannen afslay agin sket 7 unfakni feo gevilchi geld. 30. If a man slay another, let him pay with his own money, skete, and with any sound feo, cattle. Gif freeman weo frees manus with gelegio his vergeld abici 7 oder with his aginum skete beget. 7 paem odurum et pam gebrengi. 31. If a freeman lie with a freeman's wife, let him pay his vergeld, and another wife obtain with his own sket, and bring her to the other. Then follow chapters relating chiefly to injuries done and wounds inflicted, and the bots payable to the person injured for the same. It is not needful to mention more of these than the most important one, viz., that for the destruction of an eye, hand, or foot. The bots for all these in most other laws were alike. In Ethelbert's laws, the bot for each of the 3 is 50 skillings, which happens to be the same as the munbird of the king. After the clauses for injuries, there are several relating to women. Gif free with lokbor les ves havet gedep 30 skilling gebet. 73. If a lock-bearing free wife does wrong, 30 skillings bot. Majpabat svi swa frigus manus. 74. The maiden bot is like a freeman's. Mund per bestain, widuan, erlkundre, 50 skilling gebet. Dar opre, 20 skilling, oare pridden, 12 skilling, per feodoran, 6 skilling. 75. The mund of the best Earlkund widow is a bot of 50 skillings. Of the second rank, 20 skillings. Of the third, 12 skillings. Of the fourth, 6 skillings. Gif mand widuan unaging gemimp 2 geld seo mund sai. 76. If a man carry off a widow not in his mund, her mund shall be twofold. The clause relating to the mund of the 4 grades of apparently Earlkund widows does not help us much to an understanding of what the grades of Kentish society may have been. But it emphasizes a remarkable trait of these laws of Ethelbert. Every class is divided in these laws into grades. The clergy are divided into grades from bishops to clerks. The female servants of the king's household are divided into 3 classes, and so are the servants of the ceorl's household. The layates are divided into 3 classes, and now the widows, whether all Earlkund or not, are divided into 4 classes for the purpose of their mund. The significance of these divisions will be apparent hereafter. In the meantime, the mund is probably the amount to be paid by a second husband to the parents or kindred of the widow. Passing from the mund of the widow, the following clauses throw some light upon the positions of the wife under Kentish custom. Gif mon majp gebegio keapi gekehapad sai gif hit un fakni is gift it pone fakni s f per et ham gebrenge 7 him man his skeet agef. 77. If anyone buy a maid, let the purchase stand if without guile. But if there be guile, let him bring her home again, and let them give him his money back. Gif hio quick bairn gebrip helfni skeet age gif curl sveltip. 78. If she bears a living child, let her have half the property if the husband die first. Gif mid bernum bugan will helfni skeet age. 79. If she wills to go away with her children, let her have half the property. Gef Carol Egan Weil Swa and Bairn. 80. If the husband wills to have them, let her have as one child. Gef Hio Bairn ne Gebrep Fadering Magas Fio Egan 7 Morgan Fife. 81. If she bear no child, let her paternal kindred have the property and Morgan gift. It is obvious from these clauses that under Kentish custom, the position of the wife was very much the same as under Cymric and continental German custom. The marriage was a fair contract between the 2 kindreds. The next clause enjoins a payment of 50 shillings to the owner of a maiden if she be carried off by force. Lastly, there are the following clauses relating to the position of the esne under Kentish custom. The esne is considered to be a servus working for hire rather than a theo. Gif man mid esnes quien gelip be quickum corle to gebet. 85. If a man lies with an esne's wife, the husband alive, double bot. Gif esne operne afsle unsinnigi elne werde forgeld. 86. If one esne kills another innocently, let the full worth be paid for. Gif esnes age 7 foot of werodep aslagan, elne werode hein forgeld. 87. If an esne's eye and foot are struck out or off, let the full worth be paid for it. Gif men manes esne gebendep 6 skillings gebet. 88. If a man binds a man's esne, 6 skillings bot. There is nothing in these clauses, I think, to show that the bot was payable to anyone but the owner of the Esne. What the full worth of the Esne was, we are not told. 4. The laws of Hothleter and Edric, AD 685 and 6. Between the date of the laws of Ethelbert and those of other Kentish kings, which have been preserved nearly a century, had intervened, so that these later laws of Kent are nearly contemporary with King In's dooms of Wessex. As in Ethelbert's laws, the main division of classes of freemen seems still to have been that between Earlkund and Corlys. But we get further valuable information. The laws of Hlothere and Edric open with the clauses which seem to fix the vergeld of the earl at 3 times that of the ordinary freeman. They deal with the liability of an owner of an Esne for his servants' homicides. Gif manus Esne Earlkundni mannen of Sleho, pene pe sio preum hundum skilling gilde se agend pon bannen a gef 7 du per prio manwiro 2. 1. If anyone's Esne slay an Earlkund man, one that is paid for with 300 skillings, let the owner give up the slayer and add 3 manworths thereto. Gif sebana odbirsti feordi manword, he to Gado 7 hein, gekenen mid godum awadum p he pane banem begetten nemeten. 2. If the slayer escape, let him add a 4th manworth, and let him prove with good compurgators that he could not catch the slayer. The next 2 clauses are as follows. Gif manus Esne frigne mannen of Sleo, pene pesi hund skillinga gelda se agend pone bannen a gef 7 oper manword pertu. 3. If anyone's Esne slay a free man, one that is paid for with 100 skillings, let the owner give up the slayer and a 2nd manworth thereto. Gif bana odbersti tam manwedrum, heine man forgeld 7 heine gekan, mid godum awedum pe he pan bane begetten ne mitte. 4. If the slayer escape, let the owner pay for him with 2 manworths, and let him prove with good compurgators that he could not catch the slayer. The reading of these clauses is not that of Thorpe or of Schmid, but that approved by the best authorities. Following this reading as philologically the most correct one, the inference at first sight might be that under Kentish law, the vergeld of the Earlkund men was 300 Kentish skillings, and that of the free man 100 skillings. But there may be reason to doubt the correctness of such an inference. For the present, we may leave the question of the amount of the vergelds to consider the meaning of the clauses and their main intention. And this seems to be clear. Henceforth, the owner of an Esne was not to be accountable for the vergeld of the person slain, or any part of it further than that if an Earlkund men payable for with 300 skillings be slain, he must hand over the Esne and 3 times his manworth in addition. And in the case of the freeman payable for with 100 skillings, he must hand over the Esne and add 1 manworth in addition. That is to say, the Esne was in both cases to be handed over in a manworth for each 100 skillings of the amount at which the person slain is paid for. Now I think we must conclude that these clauses were intended to make an innovation upon ancient custom rather than to confirm it, and therefore it may be well to compare with them the parallel evidence of the laws of other tribes as to the responsibility of an owner for his slaves' homicides. Under the Welsh laws, 2, page 105, the liability of the owner of a slave for his homicides was apparently complete. If a bondman commit homicide of whatever kind, it is right for the lord of the bondman to pay for the deed of his bondman as for a murderer, for he is a murderer. And this probably must be taken as the general rule of tribal custom in its early stages. In the laws of the Saxons and of the Angli and Verini, the ancient German tribal custom was still preserved. The owner of an animal or a slave was liable for any injury done by either, very much as if it had been done by himself. Lex Sax 7, Ang and Ver 16 and 52. But it would seem that Roman and Christian feeling very early suggested that this was hard upon the innocent owner. Hence, in some of the laws, the compromise was made that the owner should pay only a half Wehrgeld and hand over the offending animal or slave instead of the other half. That this innovation was not altogether acceptable to tribal feeling is shown by clauses in the Pactus III of the Alemannic laws. The whole Wehrgeld was to be paid by the owner if his horse, ox, or pig killed a man, S. 18. But an exception was made in the case of the dog. If a man's dog killed anyone, a half Wehrgeld, medium Wehrgeldum, was to be paid. And if the whole Wehrgeld was demanded, all the doors but one of the house of the person making the demand were to be closed, and the dog was to be hung up 9 feet from the only one left open for ingress or egress, and there it must remain till it fell from putrefaction. If it was removed or any other door was used, the Wehrgeld was to be returned. S. 17. Grimm, Dr., page 665, has pointed out that in the Ostgotalaga, Drap 13.2, a similar archaic practice is described when a slave had killed a man. The owner of the slave under his law ought to pay the whole Wehrgeld, and if he did not do so, the slave was to be hung up at his, the owner's, house door, till the body putrefied and fell. Thus, the same archaic method of punishing the delinquent was retained in both cases. But the significant point is that so long as the whole Wehrgeld was due from the owner, it was at the owner's door that the body of the slayer was to be hung up, while when the half geld only was to be paid, the dog was to be hung up at the door of the person who improperly demanded the whole Wehrgeld. Thus, as in so many other cases, the 12th century laws of the North preserved the earlier custom of the payment of the whole Wehrgeld, while the Alemanni, after migration into contact with Roman and Christian civilization, in their laws of the 7th century modified the custom, at the same time retaining the archaic method of forcing compliance with the modification. It must be remembered that every change which relieved the innocent owner from liability, wholly or in part, robbed the kindred of the person slain of the whole or the part of the Wehrgeld. The compromise of payment of the half Wehrgeld and the handing over of the offending animal or slave was not confined to the Alemannic laws. In the Ripuarian Law 46, the animal which had killed a man was to be handed over and received in medietatem Wehrgildi, and the owner was to pay the other half. In the Lex Salica, the same rule was at first applied to the case of homicide by a slave or layet. A half Wehrgeld was to be paid, and the slave or layet handed over for the other half. This was the rule according to the Codex 1, but in the later codices 7 to 10, and in the Lex Edmundata, the lord, if innocent, was allowed to get off altogether from the half Wehrgeld, and had only to give up the slave or the layet. This further innovation seems to have been connected with the Edict of Chilperic, circa AD 574, and thus probably represented the result of ecclesiastical influence at very nearly the date of the earliest Kentish laws. We have only to recur to the canons of the Celtic Church of Brittany and South Wales of the 6th and 7th centuries, considered in the earlier part of this volume, to recognize the hand of the Church in these innovations upon earlier tribal custom. They extended to Celtic as well as to German districts. In Canon 5 of the so-called Canones Vallici, the rule was laid down that if any master should permit his slave to carry arms, and the slave killed a free man, the owner must hand over the slave and another besides. Supra, page 108. The half Wehrgeld here is omitted altogether, and, as in the case of the Kentish freeman, 2 slaves are to be given up instead of 1. These canons were nearly contemporary with later Kentish laws, and the same stage of innovation seems to have been reached in both. A still further and final stage had been reached in the Burgundian law already quoted, Supra, page 124, in which, in the case of homicide by a slave unknown to his master, the slave was to be delivered up to death and the master was to be free from liability. The parentes of the slain person were to get nothing, not even the slave, because as we enact that the guilty shall be extirpated, so we cannot allow the innocent to suffer wrong. The whole process of change had taken place in the Burgundian district by the 6th century, But it would seem that in Kent, the middle stage had only been reached at the date of the laws of Lothair and Edric. Evidence that the further stage had at last been reached in Anglo-Saxon law is perhaps to be found in the nearly contemporary law of Ine, S. 24, which enacts that if a Theowelth slay an Englishman, the owner shall deliver him up to the Lord and the kindred, or give 60 shillings for his life. Here no further manworths are required, but possibly the peculiar position of the Theowell may have something to do with it, so that we ought not perhaps to assume as certain that the clause represented a still further general innovation upon tribal custom beyond that described in the Kentish clauses. Returning to the Kentish clauses, and assuming that their direct intention was to modify previous custom, we are now in a position fairly to judge what the previous rule may have been. Reasoning from the analogy of other laws, it seems most likely to have been to make the owner pay a half vergeld of the person slain, and hand over the esne for the other half. The stage of custom reached in the Ripuarian laws and Salic laws of Codex I. And if this were in fact the former custom previous to the enactment in these clauses, then without departing from the correct literal reading of the text, it may be that the words in the parentheses in each clause may refer not to the Erlkendmen's or the freeman's vergeld, the word leodgeldi is not used, but to the amount hitherto payable in the particular case of a man slain by an esne. The 300 and 100 skillings may be the half vergeld hitherto payable, instead of which thenceforth the owner of the esne is to pay 3 mansworths, or 1 manworth, in addition to handing over the esne. If previous to the innovation the Erlkendmen had been paid for in such a case with 300 shillings, and the freemen with 100, the words in their strictly correct literal meaning might perhaps rightly be read thus: If anyone's esne slay an Erlkendman, one who is now paid for at 300 skillings, let the owner in future give up the slayer and add 3 manworths of the esne thereto. If anyone's esne slay a free man, one who is now paid for at 100 skillings, let the owner in future give up the slayer and add 1 manworth of the esne thereto. This reading of the clauses, putting emphasis upon what is now the guild, Bain Bay C, the 3 and the 100 skillings, in contrast with what the owner has in future to do, i.e. pay 3 manworths and 1 manworth, instead of the 300 and 100 skillings, in addition to the handing over of the esne, seems to me more than any other rendering to account for the insertion of the parentheses stating the amounts payable for the Erlkendmen and freemen. If the word leodgild had been used, it might have been different, but I am informed on the best authority that the words gild and geld in the 2 clauses are not substantives, but used in an adjectival sense, and in this case they would apply to a half vergeld payable as correctly as to a whole one. At the same time, the mention of 100 skillings, if the payment be a half vergeld, may help to an understanding of the medum leodgeld of 100 skillings mentioned in Ethelbert's laws. It suggests that the medum vergeld was a modified or middle one which, like the medium vergeldum and medium precium of the medieval Latin of the Alemannic and other laws, had come to mean a half one. Perhaps, after all, if we recognize clerical influence in the framing and modification of Kentish laws, the translation of the Latin medium vergeldum by the Anglo-Saxon medium leodgeld is not very unnatural. Before we leave the laws of Lothair and Edric, there are 1 or 2 further clauses worth notice. Clause 5 reminds us that though scarcely mentioned in these laws, the system of compurgation was in force. A freedman charged with a crime has to clear himself by the oaths of a number of free awad men. Clause 6 makes mention of the protection of a woman by her kindred. Gef Carol Aquili be lebendum wife 7 bairn, right is p het p, bairn meder, folgage 7 him mon, and his Phaedring magum vilsume berrigan, Gesell his feo to Helden, apat he 10 wintra c. 6. If a husband, Carol, die, wife and child yet living, it is right that the child follow the mother, and let that sufficient guardian be given to him, the child, from among his paternal kinsmen to keep his property, cattle, till he be 10 winters old. These clauses, unimportant perhaps in themselves, are useful as showing that behind the silence of the laws, tribal custom still lingered on. However seldom and slightly it might be brought into evidence, as fresh circumstances might suggest new clauses. There are also some clauses which are useful as showing the continuance of the mundbirds of the king and curl of King Ethelbert's laws, unchanged in amount a century later. By S11, if a man uses abusive words to another in anyone's flet, let him pay 1 skilling to him who owns the flet, and 6 skillings to him to whom he said the words, and 12 skillings to the king. So also in S12, 1 skilling is to be paid to the owner of the flet, 6 skillings to the person wronged, and 12 skillings to the king. The 6 skillings to the person insulted or wronged is the mund of the freeman or curl. Lastly, in S13, in case of a slaying in a drinking bout, gif man weapon breged per main drinken, 7 per man nan ifil ne ded, skilling pan pay flate, age 7 signe 12 skilling. If a man draw a weapon where men are drinking and no harm be done, then a skilling to him who owns the flet, and 12 skillings to the king. Gif pay flet geblod gad, word vergeld pem main, his mund beard 7 sig 50 skilling. If the flet be stained with blood, let him pay to the man who owns the flet his mund bird, and 50 skillings to the king. Thus we have again the mund birds of King Ethelbert's laws. Of the king, 50 skillings. Of the curl, 6 skillings. The crime of killing another in a drinking bout is a breach of the mund of the owner of the flet, as well as a breach of the peace of the king. End of section 33. Section 34 of Tribal Custom in Anglo-Saxon Law. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Read by Kristen Hand. Tribal Custom in Anglo-Saxon Law by Frederic Seebohm. Chapter 14, The Laws of the Kentish Kings, Part 3. 5. The Laws of King Witred, A.D. 690 to 696. One more chance remains for further information regarding Kentish vergelds, viz., in the laws of King Witred, who became king of the Kentish men about A.D. 690, and, according to Bede, died A.D. 725. A century had passed since the laws of Ethelbert were enacted in the time of St. Augustine. Britwald was now Archbishop of Canterbury, and at an assembly of church and people, the great men decreed, with the suffrage of all, these dooms, and added them to the lawful customs of the Kentish men. These laws are mainly ecclesiastical, both in their origin and subject. In the first 2 clauses, the church was declared to be free from gaffles, and the mund bird of the church was declared to be the same as the king's, viz., 50 skillings, as in Ethelbert's laws. There is therefore no marked change in the Kentish currency, though by this time it must have been almost entirely silver so far as any Kentish coinage was concerned. Clause 5 introduces us for the first time in the Kentish laws to the distinction between the Geiskund and the Korslik classes. Gif peisch gerverd Geiskund, mannen ofer bis gemont bihi Unrit Hamed Gainme Ofer Singais Bibod 7 Biscopes 7 Boca Dom Se Pe Gebet his Drayton 100 skilling and Eld Ret Gif hit Kerlorsik man say Gebet 50 skillings. When it happens to a Githskund man after this Gemet that he enters into unlawful marriage against the command of the king and the bishop and the book's doom, let him make bot for it to his lord with 100 skillings according to ancient law. If he be a Kurlsic man, let him make bot with 50 skillings. It would not do to conclude from this single allusion to Geithskund and Korslik men that the Kentish division of classic, Earlslick and Corlslick, had given way before the Wessex division of classes, Geithskund and Korslik. There had been no interval between this and the last set of Kentish laws long enough to have made likely any radical change in social conditions, and, as the ancient law alluded to was probably ecclesiastical and not especially Kentish, either in its origin or its terms, it would not be wise to build anything upon the use of the word Geithskund beyond recognizing the natural tendency of neighboring peoples under the same ecclesiastical influence to approximate in phraseology, especially in regard to matters of general ecclesiastical interest. Clauses which follow, regulating the penalties for work on Sundays or neglect of baptism, or a churl's making offerings to devils without his wife's knowledge, or a man's giving flesh meat to his family on fast days, do not interest us in this inquiry further than as revealing lingering traces of paganism and the ecclesiastical character of these laws of Whitred. There are, however, a few clauses which incidentally come within the lines of our inquiry. Clause 8 is especially interesting as showing that when freedom was given by a lord to his man, and he became folk free, still, even though he left the district, his inheritance, his vergeld, and the mund of his family remained with the freedom giver. Gif man his main, and wioft friols gef, say see folk fry, friols gefa, age his urfa iende, vergold 7 mund, par heina sai offer merce par he wille. If anyone give freedom to his man at the altar, let him be folk free. Let the freedom giver keep the heritage and vergeld and the mund of his family, be he over the march wherever he will. Here tribal custom asserts itself. The freed man, though freed at the altar, is to be folk free. And yet, although folk free and able to go wherever he will, he cannot inherit because he is nobody's heir. He had no free parents from whom to inherit. His lord inherited what his unfree man might leave behind him. The freed man's vergeld, if he were slain, still went to his lord, for he had no free kindred to claim it. His family remained in the lord's mund unless they also had been set free. These points were doubtless all incident to the position of a newly made freedman under Kentish custom, and this enactment was probably needful only to make it clear that freedom given at the altar, whatever churchmen might think, was not to modify the customary rules incident to freedom giving. The effect of the clause is, however, valuable, because for one moment it accidentally lifts the veil and shows that Kentish tribal custom was in these matters much the same as we have found tribal custom elsewhere. And it is particularly valuable as direct evidence that there was a class of freedmen under Kentish customs as everywhere else. There are also the following clauses on oaths. Biscopes word 7 singizes, si unlange button ade. 16. A bishop's and a king's word is unimpeachable without an oath. Minstres aldor hein cayen and preots cayen. 17. A minister's elder clears himself in the same way as a priest. Priost hein cleansi salfe sode in his halgum fragle et foran wioft pus quinde irritatum dicu in expo non mentior swilsi diacon heine cleanse. 18. A priest clears himself by his own declaration in his holy garments before the altar, saying, I speak the truth in Christ, I do not lie, and so also does the deacon. Cleroc feora sum hein kleinse, his hefod gemanse, 7 ane, his hand on weofod odre estenden ad abaiken. 19. A cleric shall clear himself as one of 4 of his like, with one hand on the altar, the others standing by and accompanying the oath. Geist hein clense silfes, aid on weofode, swalsi signi peng. 20. A stranger, geist, shall clear himself by his own oath at the altar, and in the same manner as a king's thane. Korslik manhein fawara sum his hefod gemense en weofod seven pisa elra adsi unlegne. 21. A Korslik man shall clear himself with 4 of his like at the altar, and the oath of all of these shall be unimpeachable. These statements regarding oaths, like other laws of Wihtred, betray their ecclesiastical origin, and following directly after the imposition of penalties for what may be called ecclesiastical sins, very difficult proof, seem to have been inserted with special reference to them. They are interesting, however, as reminding us again that the system of oath helpers was not absent from Kentish custom. Section 20 of this clause is also interesting, which places the stranger, guest, may we not say the king's guest, in the same position as the king's thane as to the validity of his single oath. Both seem to be specially under the king's protection. In the case of the king's thane, on account of his official or military position; in the case of the stranger, probably because of the absence of his kindred. The king being in the place of kin to the stranger, his single oath is accepted. These laws end with clauses referring to theft, more or less closely resembling those so prominent in King Ein's dooms. They state that a thief slain as a thief was to be without vergeld. If a freeman were caught in the act of thieving, the king might either kill him or sell him over sea, or release him on payment of his vergeld. He who should seize and hold him was to be entitled to the half vergeld, or if he were put to death, to 70 skillings. A man coming from far, or a foreigner, went off the public way, who should neither call aloud nor blow a horn, was to be taken to be a thief, and put to death or redeemed by a vergeld. The last clause resembles Ein's S20 so closely as to suggest a common origin. Wihtred 28. Gif feoren kumen man oppe framde butan vegganj 7 he pon nader ne harm ne he horn blau for deof he bid to profiane oppe to slain oppe to aslain. Ein 20. Gif feor kumen man ode fremde butan veg geond voodoo gong 7 ne hiram ne horn blaue for deof he bid to profien ode to slane ode to alsean. The close resemblance between these clauses confirms the suggestion that the expression geithskund in the Kentish laws of Wihtred may have been borrowed from Wessex. Nowhere else than in these contemporary laws of Ein and Wihtred does the term geithskund appear, except in the fragments of Mercian law, which may thus belong to the same period. 6. The division of classes under Kentish custom. We have now examined the Kentish law, especially regarding the amount of the vergelds and mundbirds. Although we may not have arrived at absolute certainty, yet some light may have been thrown upon the important matter of the division of classes. So far as the amounts of the vergeld are concerned, the contrast was between the earl and the freeman, the vergeld of the earl being 3 times that of the freeman. But as regards the mundbird, the contrast was between earl and curl. The mundbirds were king 50 Kentish skillings, earl 20 Kentish skillings, curl 6 Kentish skillings. There must evidently be either identity of meaning or much overlapping in the terms freeman and curl. Otherwise, the curl would be without a vergeld and the freeman without a mundbird. And yet, on the other hand, there was probably some reason why the particular words used were chosen in the several clauses, and to a certain extent it may not be far to seek. So far as the word curl had a special sense, it meant the married man, the husband with the homestead and household, like the North Country husbandman with his husbandland. In this special sense, every curl may have been a freeman, but every freeman may not have been a curl. Hence, in the clauses as regards mundbird, the contrast is between the earl and the curl. Both were men with homesteads and households. Unless they had persons under their mund, they could not have had corresponding mundbirds. The freeman who did not happen to be a man with a homestead and household could have no mundbird, because he had no precinct within which his peace could be broken, and no household under his protection. but he could have a Vergeld. So again, in the clauses quoted relating to injuries done to the servants in the laws of Ethelbert, 14. If a man lie with an earl's barrel, let him make bot with 12 skillings. 16. If a man lie with a curl's barrel, let him make bot with 6 skillings. If with a theo of the second class, 50 skaets. If with one of the third class, 30 skaets. 25. If anyone slay a curl's halfeta, let him pay bot with 6 skillings. The curl in this contrast is again a husbandman with a homestead and a household, and with burls and theos and halfetas under his roof or in his ham. Wherever in the Kentish laws the word curl is used in any other sense, I think the meaning is confined to that of the married man, the husband, as in the phrase husband and wife. So regarded, the division for purposes of Mundbird into Earlisk and Curlisk classes was natural, and so also, for the purposes of Vergeld, was the distinction between Earl and Freeman. As regards the Vergeld, we may consider the terms Curl and Freeman as practically interchangeable, inasmuch as every Curl was certainly a freeman, and the unmarried freeman was probably a cadet or member of the household of some Earlisk or Curlisk man. Continental society included everywhere, as we have seen, such classes as the Roman liti and liberty, composed of strangers and freedmen who had not so far risen in the social scale as to have fully recognized rights of inheritance, and whose Vergeld never was of the same amount as that of the full freeman. It is in connection with such classes that the tribal distinction of blood came in. If for the full freeman we were to substitute the word tribesman, with all the background of hindens of kinsmen to fight and to swear for him involved in the term, then from the same point of view we must expect to find it in Kent, as everywhere else, strangers in the blood below the tribesmen, like the Aelts and Altudes and Teogs of the Cymric codes, the Feuadheres of the Brehon laws, if not the liberty and liti of the Gallo-Romans, or perhaps still more nearly to the point, the lacing classes of the Norse laws. We have already found incidental mention of the Kentish freedman. He cannot, after enfranchisement, have been classed as an Esne or a Theo. There would seem to be no other class mentioned to which he could belong, unless it might be that of the Laets of Ethelbert's laws. It is worthwhile, therefore, to recur to the single clause in Ethelbert's laws already quoted respecting the Laets and to examine it more closely. Within the compass of its few words, there may perhaps be found evidence connecting the status of the Kentish Laet with what we have learned of the status and conditions of the Norse lacing. 26. If a man slay a Laet of the best class, let him pay 80 skillings. If one of the second class, let him pay 60 skillings. Of the third, let him pay 40 skillings. The clause does not mention to whom the payments are to be made, whether to the Laet himself, or, as in the case of the freedman, to his late owner or lord. But the payments are not called Laetgelds, as are the Vergelds of freemen. Looking to the payments themselves, they are graduated for 3 classes of Laets. There were also, under Norse custom, 3 classes of lacings, gradually growing by successive steps towards a higher grade of freedom as kindreds grew up around them and became more and more nearly perfect, till at last the 9th generation from the first freedmen became fully free. Why may not the 3 grades of Kentish Laets have been doing the same? Let us compare the amounts of the payments for the slaying of the 3 classes of Kentish Laets with those for the 3 classes of Norse lacings. We have seen over and over again that the Kentish skilling, regarded as 20 skaets, was an ore or a Roman ounce of silver. Therefore, Kentish payments stated in ounces of silver were as follows. Best class of Laet, 80 ounces of silver. Second class of Laet, 60 ounces of silver. Third class of Laet, 40 ounces of silver. The Norse ore was also in wheat grains a Roman ounce of silver. The Vergelds of the 3 classes of lacings in the Norse laws were as under: Frialskafi, or newly made freedman, 40 ores of silver. Lacing, after making freedom ale, 60 ores of silver. Lacingia, son or highest rank of lacing, whose great-grandfather was a lacing, 80 ores of silver. So that the Vergelds of the 3 classes of Kentish Laets corresponded exactly in amount with those of the 3 classes of Norse lacings when reckoned both in silver. We may further compare these payments for the Kentish layates with those for the freedmen of the nearly contemporary Bavarian laws. They are stated in gold solidi of 3 tremises, and the Kentish solidus was of only 2 tremises. We have seen that the Bavarian freedman was paid for with 40 solidi, i.e. 60 Kentish skillings. The payment thus corresponded with that for the Kentish layates of the second class. These correspondences are unexpected and very significant, but the significance is made still more important by the clause in the Laws of Wihtred describing the position of the newly made freedman under Kentish custom. The description of his position might almost be taken as a description of the frilgjafi, or newly made lacing, of the Norse laws. Under Kentish law, the freedman was to be folk free, but the freedom giver was to keep the heritage and vergeld and mund of his family, be he over the march wherever he will. This was, as we have seen, almost exactly the position of the Norse lacing before he had made his freedom ale. He had as yet no kindred to swear and to fight for him. He was still under the mund and protection of his lord. His descendants could only obtain the protection of a kindred and become wholly free from the thermsel of the lord, when in the course of generations a kindred had grown up gradually around them. So, as we have seen, under the Bavarian laws, the freedman's vergeld went to his lord. Under the Frisian law, the vergeld of the litus went to his lord. Under Ruperian law, even the homo generalis, the freedman who became a Frank with a full vergeld, was recognized as having at first no kindred. If he had no children, his property went to the fisc. And it was not till the 3rd generation that his descendants had full rights of inheritance. We have already found abundant evidence of the continued force of tribal custom and tribal instincts in regard to the importance of kindred, while considering the meaning and function of the hindens in connection with the 12 hind and twi-hind classes of the Anglo-Saxon laws. These remarkable correspondences between the position held by the layates in Kent and that of the lacings and freedmen and liti of continental laws, without our making too much of them, may fairly be taken as additional evidence of the tenacity of tribal custom in these matters. End of section 34. Section 35 of Tribal Customs in Anglo-Saxon Law. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Read by Kristen Hand. Tribal Custom in Anglo-Saxon Law by Frederic Seebohm. Chapter 14, The Laws of the Kentish Kings, Part 4. 6. The amount of the Kentish vergelds. Once more, we return to the amount of the vergelds of the Celtish earl and freeman. We have seen reason to believe that the payments of 300 and 100 skillings of the laws of Hlothere and Edric were half vergelds, and that the full vergelds were 600 and 200 skillings. If they may be so considered, they are at once put in line with the Frankish vergelds. The threefold vergeld of the earl becomes evidently due to his noble birth or official position. And if the Kentish and Frankish solidi had been alike, the similarity of the vergelds would have been complete. The vergelds of the Frankish group of laws were found to be as follows: Lex Salica, Graphio, or Ingenius Intrust Regis, 600 solidi. Frank or barbarian living under Salic law, 200 solidi. Lex Rupiorum, Comes, etc., Intruste Regis, 600 solidi. Ingenuus, 200 solidi. Lex Anglorium et Venorium Adalingus, 600 solidi. Liber, 200 solidi. Lex Chamavorum Homo Francus, 600 solidi. Ingenus, 200 solidi. In all these cases, the vergeld of the royal official or person in high rank is threefold of that of the liber or ingenus. Confining attention now to the position of the Kentish freeman, further confirmation of the view that his vergeld was 200 Kentish skillings may be derived from a comparison of the king's mundbird with his vergeld, and the corresponding continental payments pro fredo with the vergelds of the liber and ingenus of the continental laws. The Kentish mundbeard of 50 Kentish skillings was 1/4 of the Kentish freedman's vergeld if 200 Kentish skillings. The Mercian mundbeard of 5 pounds of silver was 1/4 of the Mercian vergeld of 1,200 skillings of 4 pence, or 20 pounds. The Wessex mundbeard of 5 pounds would be 1/4 of the Wessex vergeld proper if the latter might be looked upon as the same as the Mercian with the mundbeard added. The Alemannic and Bavarian payments pro Fredo of 40 solidi were 1/4 of the Alemannic and Bavarian vergeld of 160 solidi. And Brunner and others consider that although the payment pro Fredo was sometimes an extra payment, the 200 solidi of the Frankish vergeld equaled 160 solidi with 1/4 added pro Fredo. Now, if instead of holding the Kentish freeman's vergeld to be 200 Kentish skillings, we were to take it to be the Medum vergeld of 100 skillings, we should destroy the correspondence of the king's mundbeard with the vergeld, and make the mundbeard half the vergeld instead of a quarter, unlike what it was in the other laws. This hardly seems a likely supposition. We get still further evidence if we compare the payments for the eye, hand, and foot in the Kentish and continental laws. We have seen that the Kentish payment was 50 skillings, i.e., the same as the king's mundbeard, and 1/4 of the vergeld of 200 skillings. In the Alemannic and Bavarian laws and in those of the Chamvi, the payment for these, like the payment pro Fredo, was 1/4 of the freeman's vergeld. In the Frankish laws, it was 1/2. But the reason of this is not that either the Frankish payment pro Fredo or the vergeld is less than in other laws, but that the payment for the eye, hand, and foot is greater. The Frankish payment for the eye, hand, or foot was 100 solidi of 3 tremises, i.e., half as much again as the Kentish freeman's vergeld would be if only 100 Kentish skillings of 2 tremises, which again seems unlikely. At first sight, the Wessex payments for the eye, hand, and foot present an anomaly. The Wessex 12 hind vergeld of 1,200 Wessex skillings of 5 pence at a ratio of 1 to 10 corresponds, as we have seen, with the Frankish freeman's vergeld of 200 solidi. The payment for the eye, hand, and foot in King Alfred's laws is 66 2/3 Wessex skillings, i.e., only 1/18 of the 12 hind vergeld. But the explanation, no doubt, is that in the laws of King Alfred, the payments for injuries are stated for the twihind man's grade, those for the eye, hand, and foot being 1/3 of the twihindman's vergeld of 200 Wessex skillings. On the whole, therefore, these considerations seem to strengthen the supposition that the Kentish freedman's vergeld was 200 Kentish skillings. That the Kentish vergeld should differ from that of Mercia and Wessex need not surprise us, seeing that we started with the warning that we should find it so as regards both the barons and villani. To the writer of the so-called laws of Henry I, the earl was no doubt the baro, and the freeman, or curl, the villanus of Norman phraseology. And we do not need to wonder at his confusion if he had nothing but the laws to guide him. It is necessary, however, to look at the question of the vergelds from a broader point of view than his could be. It must not be forgotten that the continental vergelds of the Merovingian period were all stated in gold solidi. The first emigrants into Britain must have known this perfectly well. Kentish moneyers coined gold tremises, and when they afterwards coined silver, it was in silver tremises of the same weight, which earned the name in England of scaets. Any exact comparison of English and continental vergelds must obviously be dependent upon the ratio between gold and silver. The Kentish skilling of 2 gold tremises at 1 to 10 was reckoned in the laws of Ethelbert as equal to 20 scaets, i.e., to the Roman ounce, and the vergeld, if of 200 skillings, was thus, as we have seen, a vergeld in silver of 200 ounces, or 4,000 scaets. We have also seen that Archbishop Egbert claimed for his priests a vergeld of 200 ounces of silver, which thus would accord exactly with the Kentish vergeld of 200 skillings. It might almost seem that he may have consulted his colleague the Archbishop of Canterbury and fixed his clerical demand in accordance with the Kentish vergeld rather than that of Wessex or Mercia. Nor was there anything unnatural or abnormal in the Kentish Vergeld of 200 ounces of silver, inasmuch as 200 Roman ounces of silver at a ratio of 1 to 10 would equal the mina italica of 20 Roman ounces, or of 2 ancient Roman pounds of gold. We may therefore with confidence, but without claiming certainty, fairly state the Kentish Vergelds in Kentish skillings and skaets, thus: Earl, 600, possibly 300 Kentish skillings equals 12,000 skaets. Freeman, 200, possibly 100 Kentish skillings equals 4,000 skaets. Layet 1, 80 Kentish skillings equals 1,600 skaets. Layet 2, 60 Kentish skillings equals 1,200 skaets. Layet 3, 40 Kentish skillings equals 800 skaets. And when put together in this way, the proportion between the Vergeld of the freemen and that of the layets becomes important. In the Norse laws, the lacing's Vergeld was 1/6 of that of the Hald or Odelmen. In the Bavarian and Saxon laws, the Vergeld of the litus was 1/4 that of the freemen. Anything like these proportions in Kent would make a Vergeld as low as 100 skillings for the freemen very improbable. Lastly, perhaps it may be fair to the reader to recur once more to the question of the Kentish skilling. If any doubt should remain as to whether we are right in regarding the skaet as the silver coin of that name, 20 of which went to the Roman ounce until it was superseded by the penny of Offa and Alfred, surely that doubt must now be dispelled. For if, according to the view of Schmidt and others, the skaet were to be taken as a farthing or quarter of a skaet, the correspondence of Kentish with continental Vergelds and payments pro Fredo would be altogether destroyed. The Earl's triple Vergeld at a ratio of 1 to 10 would be only 1/6, and if 300 skillings, only 1/12, of that of the Frankish noble or official, while the Kentish freeman's Vergeld would be reduced to 1/6, or if 100 skillings, only 1/12 of that of the continental liber or ingenuus. One perhaps must not say that such a result would be impossible, but would it be a likely one? We should have to suppose that the Judish chieftain, perfectly familiar with the continental Vergeld of the freemen as 200 or 100 gold solidi, equated by long tradition with the round number of 100 head of cattle, upon settlement in Kent, reduced the Vergeld of the freemen to 1/6 or 1/12 of what it was in the country he came from. From what we know of the tenacity of tribal custom everywhere, especially as regards the amount of Vergelds, it is difficult to conceive of his doing so. 8. Result of the Kentish evidence. We are now in a position to take a broader view of the Vergelds, continental, Kentish, Wessex, and Mercian. To the incidental mention of the fact that the Kentish freeman's Vergeld, if 200 Kentish skillings, equaled the gold mina italica, may be added to the further incident that it was equal to 100 sweetest cows of the Alemannic laws. Whether accidental coincidences or not, these facts bring us back to the point with which this inquiry started, viz., the widespread normal Vergeld of 100 head of cattle and its very general traditional equation with a gold mina. The main facts elicited as to the amount of the Vergelds in the course of this inquiry are these. At the date of the Kentish laws, and generally during the 7th century, we find 3 Vergelds in use in England for the freemen. The Wessex Vergeld of 6,000 skaets at 1 to 10 equals 600 gold tremises. The Mercian Vergeld of 4,800 skaets at 1 to 10 equals 480 gold tremises. At 1 to 12 equals 400 gold tremises. The Kentish Vergeld of 4,000 skaets at 1 to 10 equals 400 gold tremises. And on the continent, we find the 2 Vergelds. Frankish, 200 solidi equals 600 gold tremises. The other 160 solidi equals 480 gold tremises. Now, in the fairly contemporary laws of the Riparian Franks and of the Burgundians, the traditional values of animals we have found to be stated as follows. Ox, 2 solidi equals 6 gold tremises. Cow, 1 solidus equals 3 gold tremises. And in the nearly contemporary Alemannic laws, the traditional values were best ox equals 5 gold tremises, medium ox and sweetest cow equals 4 gold tremises. Within the range of these variations in the ratio between gold and silver, and in the local value of animals, there seems to be ample room and reason for the variations in the money values of the Wehrgelds. 1. 100 oxen of 6 tremises, i.e. 600 tremises, equal the Frankish Wehrgeld of 200 gold solidi, and at 1 to 10 the Wessex Wehrgeld of 6,000 skaets. 2. A long hundred of 120 cows of 4 tremises, i.e. 480 tremises, would equal the Wehrgeld of 160 gold solidi, and at 1 to 10 the Mercian Wehrgeld of 4,800 skaets. 3. 100 cows at 4 tremises, i.e. 400 tremises, make the Kentish Wehrgeld of, if we are right, 200 Kentish skillings of true tremises, and at 1 to 10, 4,000 skaets. If we change the ratio to 1 to 12, then a Kentish Wehrgeld of 100 cows of 4 tremises would in silver equal the Mercian Wehrgeld of 4,800 skaets. In other words, the difference between the Kentish and Mercian Wehrgeld may be explained either as one between 100 and 120 cows, or the number of cows remaining at 100 between the ratios of 1 to 10 and 1 to 12. There is thus, in these fairly contemporary values of Western Europe, in the 7th century, or within the Merovingian period, so obviously room for the variations in the Wehrgelds, that whether as to the origin the differences may be of historical interest or not, at any rate, for our present purpose, we are fairly warned by the general coincidence in the Wehrgelds not to make too much of the differences. The Kentish laws, therefore, lead us with some confidence to recognize the practical identity of the Wehrgeld of the Kentish freemen with that, not of the Wessex ceorl, but of the 12 hindmen. We have been led cautiously, step by step, to this result, and whether the problem raised by it be capable of solution or not, it is important that it should be fairly stated and considered. Even if the Kentish freedman's Wehrgeld was only 100 Kentish skillings, it would more nearly correspond with the 6 hindmen's Wehrgeld than that of the Wessex ceorl. On the other hand, the Wehrgelds of the Kentish layates are very fairly on a level with that of the Wessex ceorl. Taking an average between the second and third class of layates, the correspondence would be exact. If therefore the Wehrgeld of the Kentish freeman may be regarded as practically equivalent to that of the continental liber or ingenuus on the one hand, and to that of the 12 hindmen of the Anglo-Saxon laws on the other hand, and if that of the Kentish layat was like that of the Norse lacing and of the twi hindmen, then once more it becomes natural and right, and in accordance with ancient custom, that in the compact between Alfred and Guthrum, the 12 hindmen should be made equally dear with the Norse huld, and so with the liber or ingenuus of the continental laws, while the twi hindmen should be held equally dear with the Danish lacing. End of section 35.
Section 36 of Tribal Custom and Anglo-Saxon Law. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Tribal Custom and Anglo-Saxon Law by Frederic Seebohm. Chapter 15, General Conclusions, Part 1. Before concluding this essay, it may be well in the final chapter to consider its results in their bearing upon the conditions of early Anglo-Saxon society, and especially with regard to the division of classes and the character of the holdings. The object has been to approach these difficult questions from the point of view of tribal custom. The main clue to an understanding of the division of classes has been the amount of the Wehrgelds. The trouble taken to arrive at a correct knowledge of the currencies in which the Wehrgelds were paid, tedious as it may have seemed to the reader, will not have been thrown away if it has led to the recognition of the fact that there was a very general correspondence in the amount of the Wehrgelds tenaciously adhered to by the tribes of Western Europe, whether remaining in their old homes or settled in newly conquered countries. The amount of the Vergels was not seemingly a matter of race. Cymric and German customs were singularly similar. If the Irish Eric Finney formed an exception, Irish tribal custom nevertheless had many things in common with Cymric and German custom in other respects. It was from a study of the Vergels and the rights and liability of relatives and their receipt and payment that some idea was gained of the solidarity of the kindred under tribal custom, and this solidarity of the kindred was found to be closely connected with the family character of tribal landholdings, of which the Cymric Welly was a typical example. Where direct evidence of this family element was wanting, the liability of the kindred for the Vergeld remained as an indication that it once had existed. In reviewing the evidence of these matters and attempting to bring the results to a focus, we begin with the fact that with comparatively few exceptions, the normal Vergeld of the full or typical freeman was everywhere so large, 200 gold solidi, the heavy minute of gold, traditionally representing 100 head of cattle. This Vergeld was too large by far for the individual slayer to pay, and possible only as a payment from one group of kindred to another. We have seen reason to infer from the Kentish, Wessex, and Mercian Vergels that the Anglo-Saxon tribes shared in these traditions, and, so to speak, brought their Vergels with them into Britain, and we have found that Anglo-Saxon custom as regards the Vergels was substantially similar to that of the continental tribes. From Beowulf we learned that, as there could be no feud within the kindred, a homicide within the kindred could not be avenged or compounded for. There was no Galanus or Vergeld in such a case, under either Cymric or German custom, and evidence was found in the so-called laws of Henry I that it had been so also under Anglo-Saxon custom. Up to the time of the Norman conquest, the punishment of parricide was practically left by the laws to the spiritual jurisdiction of the Church. The principle which required both paternal and maternal relations to join in the payment and receipt of Vergels, and nearly always in the proportion of 2/3 and 1/3, was also common to Cymric and German tribes. This principle depended upon a view of marriage likewise common to both. A blood relationship was established as regards children of a marriage, while husband and wife for many purposes remained in their own kindreds, there being no blood relationship between husband and wife. The husband's kindred alone were liable for his crimes, and the wife's alone for her crimes, and neither the husband nor the wife received any portion of the other's Vergeld or was liable for his or her homicides. Such was the custom under the Cymric codes and the laws of the Brets and Scots, and Anglo-Saxon custom as described in the so-called laws of Henry I was similar. The tribal feeling which allowed tribesmen and strangers to live side by side under their own laws, and made the Salic and Ripuarian Franks award a full Vergeld to tribesmen of allied German tribes, while it gave only a half Vergeld to the Gallo-Roman possessor who was not of their blood, was, it would seem, brought with the invading tribes into Britain. Danish and English tribesmen were allowed to live side by side under their own laws, and acknowledged as equally dear with a similar Vergeld, while, at all events in the cases which come unto notice, complete strangers in blood were awarded only a half Vergeld, as in the continental laws. We have not attempted to settle the question how far there was a Romano-British population left in the towns, but we have found incidental traces and hints that in Northumbria, Wessex, and Mercia, there were Willis men, Welsh or British, who had only a half Vergeld, being treated as strangers both in this respect and also as regards the substitution of the ordeal for the oaths of kindred. The principle that a man who could not bring to his protection the oath of his kinsman must be brought to the ideal was one of widely extended tribal custom, and it was emphasized by the adoption of the ordeal as a Christian ceremony solemnly performed in the churches under both Frankish and Anglo-Saxon law. There can be little doubt that in the solidarity of the kindred under tribal custom, we have to do with the strongest instinct which everywhere molded tribal society. So far as it had its way and was not confronted by more potent forces, it must have almost necessarily ruled such matters as the division of classes, the occupation of land, and the modes of settlement. When we inquire into the grades of society under tribal custom, they seem everywhere to have their roots in the principles of blood relationship. A man who has no kindred to protect him needs and seeks the protection of a chieftain or lord. By the force of tribal gravitation, he sinks into the dependent condition of living upon another's land. Whether he be a freedman who has risen from the rank of the thrall, or a free tribesman of low position, or one of a conquered race, or a stranger immigrant, and whether he be courtier or the holder of the typical yardland, until in the course of generations a kindred has grown up around him, he remains in the dependent condition. He is indeed a freeman as compared with a theo or thrall, but when Alfred and Guthrum made their compact and agreed that Dane and English shall be reckoned as equally dear as the normal vergeld of the full freeman, it is not of the dependent class they are thinking. They give to this class and to the Danish lessing, or newly made freedman, a twihind instead of a 12-hind vergeld. It might at first sight be supposed that this twihind condition of the dependent class in England, so far as it may have included Anglo-Saxons, must have been the result of degradation in social status between the first settlements in the time of King Alfred, but we have sought in vain for evidence of an earlier higher position in the laws of King Ini. And on the whole, even when regarded solely from a tribal point of view, it does not seem unlikely that strangers in blood and freedmen and dependent followers of the conquering chieftains should find themselves after conquest and settlement in the economic condition of tenants and gelders on the lands of protecting lords. Nor would it be strange that, when in a new country and under other influences, this uniform dependent economic condition at once become a general fact, the whole class, in spite of variety of origins, should find itself marked by a twihind vergeld. It does not follow, however, that because in the compact between Alfred and Guthrum, the twihind class were reckoned as equally dear with the Norse lacing, that the Anglo-Saxon Curl, who sits on Garfold land, was generally in as low a social position as the Norse newly made freedman. It is enough that according to the evidence, he was a dependent tenant, let us say, under the lordship of a 12-hind man, or of settled upon royal demesnes, of some geseth, or official of the king. Still, it may be well to look once again at the position of the Norse lessing, because, after all, it is with the lessing that the Anglo-Saxon twihind Gaffagelda was equated in a compact made after King Alfred's victory, and so when the two chieftains seemed to be treating on equal terms. Surely King Alfred was not intending to degrade the Anglo-Saxon dependent class. Presumably he was making a good bargain for them. The early Norse laws were settled long after the date of this compact, upon the conversion of South Norway, and, as in other cases, they were framed with the express purpose of making room in the legal system for the Christian Church, and so in some sense with its sanction. And yet so deep was the gulf between classes, even then, that a certain portion of the churchyard was set apart for lessings, and in no case were they to be buried in the portion reserved for classes above them. And if, after giving his freedom ale, and so attaining the first step in freedom and independence, the lacing should die, leaving destitute children whose support ought not to be thrown back upon his lord, we have seen that the way out of the difficulty was to dig a grave in the churchyard into which the lessing's children were to be placed, and left to starve to death. the last survivor being the only one which the Lord thenceforth had to maintain. This was the position of the lacing at the bottom of the ladder of freedom. But we have found the lacing of the Norse laws rising by steps into greater freedom and better social position, and the process throughout was founded upon the gradual growth of kindred. It was the lack of kindred to swear for them and defend them which placed them low in the social scale, and it was the gradual growth of kindred generation after generation which marked the steps of their rise into better social position with higher virgals. When we turn to the Anglo-Saxon laws, we seem to detect similar tribal principles originally at work but with differences, which may very probably be referred to the circumstances attendant upon conquest and settlement in Britain. The law of tribal gravitation here as elsewhere, aided no doubt by other potent forces, had been at work placing the man with an imperfect kindred in a dependent position at the bottom of the social ladder. And it is important to note that at first the middle rungs of the ladder by which a man could climb out of the dependent position seem to have been present here as in Norway. The evidence is scanty, but sufficiently important. From the Kentish laws, the presence of stepping stones into greater freedom may be inferred in the case of the three classes of lets, with their rising virgals, and in a precious fragment of ancient custom happily rescued from oblivion, we found evidence that, originally at all events, there had been a way out of the curl's twy-hand condition of the fourth generation of landholding, connected with payment of gafal to the king's atware and direct service to the king. But we recognized that the collector of the fragment looked longingly back to ancient custom, speaking of it in the past tense, as if it was no longer in force. It would obviously not be wise to trust solely to the negative evidence of the silence of the laws, but in this case the silence seems to confirm the evidence of the fragment, for the pathetic tone of the fragment finds an echo in the fact that all traces of the middle rungs in the ladder seem to have vanished from the later laws. There is no mention of Indy's laws or in Alfred's of there being or having been several grades of freedmen or lets. Even the half-virgeld of the six-hind stranger, who has risen to the possession of 5 hides, silently disappears after King Alfred's time. From whatever cause, so far as the evidence goes, the twy-hind class seems to have become a homogeneous class in which, in spite of different origins, distinctions were merged in a common economic condition. Differences of origin were perhaps forgotten as the result of comradeship in the long struggle against the Danish foe. We thus seem to be driven to recognize the width and to some extent the bridgelessness already in King Alfred's time, if not in King Inny's, of the gulf between the position of the 12-hind landed class and that of the twy-hind dependent class, of Gaffagelders and Gebers, who were tenants on their land. It seems probable that, though technically and really free in the sense of not being thralls, the twy-hind class, broadly speaking, may have found themselves very early, if not from the first, placed in an economic condition of service and servitude, including work as well as gafal, which, by the ultimate difference of the middle rungs of the ladder, might very easily slide into what is loosely called the serfdom of later times. In the meantime, we realize that the abjectness of this semi-servile condition may be very easily exaggerated by modern associations with the terms service and serfdom. It is when we turn from the twy-hind class to the position of the class above them, of Gesetgund and 12-hind men, that we learn that a part at least of the risk of misunderstanding may lie in the difference between the tribal notion of service and freedom and the more modern one. What, then, has tribal custom to teach us as to the position and services of the 12-hind class? Reverting once more to the combat between Alfred and Guthrum, Dane and English are to be equally dear at 8 half-marks of gold. The Englishman, without any limiting adjective, is the 12-hind man, and he is put on a level with the Danish typical free landholder, the Hald or Alderman of the Norse laws, whose vergeld under Norse law was that of the typical freeman everywhere, equivalent to the normal vergeld of 200 gold solidi, the mina of gold, the traditional vergeld of 100 head of cattle. It was 6 times that of the Norse lessing, just as the 12 hinderman vergeld in England was 6 times that of the curl who sits on gaffald land. The English 12-hind man is therefore put on a level with the Norse odeler, or typical landholder, and so, as we have seen, the curl who rose by the middle rungs of the ladder into the 12-hind position had inter alia to become a landholder of 5 hides, and his family became gesticund only after the landholding had continued to the 4th generation. His great-grandchildren then became gesticund with the 12-hind vergeld. The 12-hind men were therefore landholders, surrounded in principle at least, if not in practice, by a kindred. But what kind of a landholding was it? Approaching the question strictly from a tribal point of view, the solidarity of the kindred involved in the payment and receipt of vergelds would certainly suggest that those who had a right to receive and the obligation to pay held a position in their kindred quite different from that of the modern individual owner of land. The analogy of Welsh and Irish and Salic and Norse and Scania tribal custom would lead us to infer that the Anglo-Saxon settlers in England must have brought with them traditions of tribal or family ownership more or less of the type of the Cymric Gweli, though doubtless modified by emigration and settlement in a new country. After all that has been said, traditions, perhaps actual examples of the individual ownership of the Romanus possessor, and still more likely, actual experience of the Roman type of landed estates, may have survived in Britain from the period of the Roman occupation, and the Anglo-Saxon settlers may easily have been influenced in the matter of landholding by what, as conquerors, they came to supplant. But they can hardly have wholly cast off their own tribal traditions and instincts. The continued payment and receipt of vergelds shows that they did not. Even, to take an extreme case, if they came to Britain as single settlers, having left their kinsmen behind them, still kindreds would gradually grow up around their descendants in the new country, and tribal custom left to itself would give to them landed rights, quite different from those of the individual owner. But the interval, apart from other outside influences, may well have subjected tribal custom to a strain. From the point of view of this interval, it may not be unreasonable to revert to the clauses of King Alfred's laws on kinless men, and the Norman precedent, that the king was to take the place of the missing maternal kindred and of advocate for a Norman if he had no other. Unless, therefore, the 12-hind settler was surrounded by a full kindred in the new country, he must, according to his own tribal custom, have found himself much more of an individual than he was used to be, and therefore more dependent upon the protection of his chieftain or king. We must not, on the one hand, conceive of the 12-hind settler as having all at once adopted the independent position of the Roman possessor, though circumstances may have sometimes severed him as completely from his parentia as the ceremony of the Salic law. Nor can we, on the other hand, conceive of him always as a tribesman surrounded by his kindred. He may evidently, on the one hand, be released from many of the trammels involved in membership of a kindred, but on the other hand, he is thrown more than ever under conditions of service to the king. Let us for a moment revert to the tribal conception of these trammels and services. They did not always involve degradation of social condition. They often, as we have seen, were the mark of the attainment of a higher position. The kindred of the Alets or strangers who settled upon a chieftain's land under Cymric custom was acknowledged in the 4th generation of continued occupation. But at the moment a kindred was acknowledged, its members became Cbteddy. When the Irish Fudir did the same, his descendants of the 4th generation found themselves not only bound to the land, but also bound together by something like the rules of the Cymric Wali, so that one of them could not sell or charge a share without the consent of the others. We found the same thing in Norway, where the rules for payment of the vergels by relations were more elaborate than anywhere else, and where the growth of kindred seems so completely to have ruled the rise from one social grade to another, till at last a man whose great-grandfather's great-grandfather was a freeborn landholder became an odler. If at first sight we were to picture the odalman to ourselves as an individual freeholder of Roman or modern type, we should soon find out our mistake when we learned that if he wanted to sell his odal, he must first consult his odal sharers. When examined closely, the fact became evident that it was the group of kindred that by long settlement on the land had become odal, and that the shares of individual in the odal were subject, with, of course, many differences, to some such tribal customs as those of the Cymric Wali. The odalman was thus not a single isolated landowner. He was surrounded by kindred odal like himself, reciprocally bound to fight for one another and swear for one another, and to share in the payment or receipt of one another's vergeld. The odalman was protected by his kindred, but his freedom of individual action was restricted by it. So also under Salic law, the joint inheritors of the alad or terra salica, with right of redivision between great-grandchildren per capita, were in the same way trammeled. And when, by a solemn public form, they released themselves from their obligations to their kindred, they relinquished also all rights of inheritance and protection. Are we to consider these continental analogies to be without relevance to Anglo-Saxon landholding? Dr. Conrad von Mora, in those masterly papers, contributed in 1855 to the Kritische Oberschau, which are still so valuable, rightly lays stress upon the power of the kindred as the great rival of the power of the state in the development of Anglo-Saxon polity. We find but little direct allusion to the kindred in the laws, it is true, but incidentally, and as it were by accident, we have learned from passages mentioned in their proper place. As the time of Athelstan, there were kindreds both 12-hind and 20-hind powerful enough to defy the king's peace. This is in itself a significant reminder that more or less of tribal custom remained in force behind the screen of the laws from which most of our evidence has been taken, and yet we seem to be almost forced to the conclusion that if we try to realize the position of the 12-hind settler, we must regard him at all events for the first few generations as in a very different position from that of the Norse odalman in the old country, even though as head of his family he may have brought descendants and dependents with him. He could not in the new country be at once surrounded by kinsmen and odal sharers, who with himself had hereditary rights in the land. We thus come round again to the point that so far as he may have been separated from his kindred, the first Anglo-Saxon settler must have found himself thrown upon the protection of his chief and into a position of individual service. He becomes, as we have seen, according to the scanty evidence of the laws of Ini, a king's guesseth, with military and judicial administrative duties to discharge, put into a post of service which he cannot relinquish at pleasure. Service to the king has to some extent taken the place of the restraints of kindred, and so in a sense, like the Twy-hind man, he has become a gaffa-gelda, but paying his gaffal and services direct to the king, an enter scriptus glibby, but tied to an estate in an official position instead of to a yardland. This view of the position of the Gesigkund and 12-hind class rests very much upon the incidental evidence of the dooms of the Idi, but the truth of it is confirmed by the independent evidence of the precious fragment already referred to, for its interesting evidence shows that, in addition to his holdings of 5 hides of land, it was precisely into this position of gaffal paying and service direct to the king that the curl of ancient custom had to climb in order to earn the Cbteddy status, and the 12th Hind Vergeld. Thus we arrive at a definite and practical mark distinguishing ultimately, and perhaps more or less, from the first, the 12 Hind and Twi Hind classes. The 12 Hind, or landed class, paid gaffald and did service direct to the king. The Twi Hind, or dependent class, paid gaffald and did service to the landed class, who from this point of view were middlemen between the Twi Hind gaffalgelda and the king. We seem, therefore, thus early to arrive at something analogous to Professor Maitland's technical definition of the manor as the fiscal unit from which gaffald is paid direct to the king, while its lord is the receiver of the payments and services of its tenants. The single landholder, who is not under a manorial lord in the Domesday survey, is said to hold as for a manor, though he may have no tenants. It may be worthwhile in this connection to allude to another general feature of the manorial estate on both sides of the Channel, which, if not directly of tribal origin, must at least have worked in close sympathy with tribal custom. The Cbteddy man, officially charged with the control of a district or estate, easily became, in a manorial sense, lord of the dependent tenants upon it, and the judicial and magisterial adjunct to the lordship became a prevalent feature of the typical manor. We have seen that the sack and sock of later times may have grown from the root of the tribal principle, involved in the sacredness of the precinct or area of protection of the chieftain, and, in degree, of every grade of tribesmen who possessed a homestead. How large a place this principle occupied is shown by the prominence of the Fredas in Frankish law, and of the Munbeard in the early Anglo-Saxon laws. The manor was a complex product of many factors, and tribal custom was certainly one of them. Once again, what kind of a holding was that of the 12 Hindmen? Was it a family holding, and what were the rules of succession? Unfortunately, we do not know how far the immigrants came in kindreds and families, or as followers in gestes of military chieftains. But in any case, if we may take the evidence of place names, the great number of patronymic names of places which lead to the supposition that the holdings were family holdings. The Ham may at first have been the estate of a Gesirkund man, held direct of the king, with gaffalgeldas and gebers under him holding yardlands and doing work on his demesnes. But when it becomes an Ingham, the patronymic termination points to the lordship of the manor having been held, as time went on, jointly, in somewhat the same way as the Cymric chieftainship in the Gweli. His sons and grandsons and great-grandsons may really have had their rights of maintenance all along, and ultimately, if they were allowed to do so, they may have sometimes divided the inheritance instead of continuing to hold it jointly. Tribal instincts working alone would probably follow some such line as this. But it is easy to see that the nearer the holding of the 12 Hindmen approached to a beneficial office, the stronger would be the tendency towards single succession instead of divisions among heirs. End of section 36. Section 37 of Tribal Custom and Anglo-Saxon Law. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Trial Custom and Anglo-Saxon Law by Frederic Seebohm. Chapter 15, General Conclusions, Part 2. During the century or two after the first settlement, there was time, no doubt, for the growth of kindreds, and the Thane in the king's service would soon become the head of a family group. But, on the other hand, many influences were at work undermining the solidarity of the kindred and strengthening the manorial element. Tribal instincts die hard, but probably there never was full opportunity for the growth upon English soil of anything like the solidarity in landholding of the Norse kindreds of Odal shearers, tracing back their family possession for 4 or 5 generations. There is but little evidence on the rights of rules of succession to be found in the laws, and the silence is suggestive of the continuance of custom. Even the diplomatic evidence of wills and charters is so much restricted to bog land that it perhaps throws a shadow rather than direct light upon the ordinary devolution of land which had not become the subject of the Romanized rules of ownership, conveyance, and testamentary disposition. But if Professor Vinogradov is right in his view that folkland was that land which was still held under ancient custom, then from anything we know, in spite of documentary silence, folkland may still have been held more or less as family rather than individual property even in later times. If the suggested analogy between the terra silica of the Salic laws and the folkland of Anglo-Saxon documents could be proved, the family character of the holdings in both cases would receive confirmation. At the same time, the frequent concurrence of relatives in Anglo-Saxon dispositions of land and the common form of deprecation of future interference on their part would at least be consistent with the supposition that as time went on, the growing force of feudal principles would demand single succession to landed estates whenever they could be regarded as benefices to what might be expected. And it is worth noting that under later feudal custom, by a kind of compromise, what was really a family holding was often artificially molded for practical purposes into a single holding with apparent single succession. In the Doomsday Survey are many instances in which thanes or soldiers here and there hold manors or fractions of manors pariter or in paragio, and when the feudal tenancy in parage is examined in its fully developed form on the continent, it is found to present many resemblances to what under Cymric custom the family holding of a tribal chief of kindred might be if the chief alone were regarded as the landed person doing homage to the superior lord for all his kindred, and if, in the next stage, when the gwelly was internally divided between brothers, one of them only did homage for the rest. There were indeed in tribal custom as to the chieftainship and the constitution of the gwelly traits, which easily allowed themselves to be developed on feudal lines. For the present purpose, however, the point seems to be that within what looks from the outside like a single individual landholding, there may have been internal family divisions which are not apparent. Passing now from what may be regarded as the holdings of the 12 Hind class, more or less tending to resemble manorial estates, to the yardlands of the Twi-Hind class, room may perhaps be found even in this case for the exceptional continuance of the family element in spite of the apparent single succession. The Kentish holdings in sulligs and yokes instead of in hides and yardlands seems to go back to the earliest Kentish records. The fact that, in spite of the difference in date between the evidence of the earliest charters and that of the Doomsday Survey, and the surveys in the Battle Abbey records and the Black Book of St. Augustine, the holdings seem to have been throughout in sulligs and yokes points to continuity. And when these sulligs and yokes in the surveys are found to be very often held by the heredies of so-and-so, or so-and-so and his paries, it seems fair to suggest that in these Kentish holdings there may have been a survival of family ownership. Whether it was so or not, this later Kentish evidence shows at least that the continuance of family holdings was not necessarily inconsistent with external uniformity in the sulligs and yokes of the open field system in Kent, and if so, why may not the same thing be true in exceptional cases of the hides and yardlands of Wessex and Mercia? Contrary principles have a strange way in practice of finding a modus vivendi, till one of them at last overrides the other. It will be remembered that one of the complaints of the existence of kindreds powerful enough to defy the king's peace in King Athelstan's time came from Kent, and if these facts may be taken as evidence that the solidarity of kindreds had been better preserved in Kent than elsewhere, some tribal light might perhaps be thrown upon the survival of the custom of gavelkind in Kent. It is not a matter upon which we must dwell, but evidently the gavelkind tenure must have been something different from the prevalent tenures of other districts. The difference cannot have been the equal division of the sulligs and yokes between sons as contrasted with the single succession to the yardlands of other districts, because the sulligs and yokes were apparently not interfered with by the gavelkind division among heirs, and when the right of the youngest son under the custom of gavelkind to succeed to the parental hearth is compared with the similar rights of the youngest son in the case of the Cymric Welly, the inference becomes very strong that the gavelkind holdings were family holdings, and the gavelkind divisions internal divisions within the family, like those of the Cymric Welly, not necessarily interfering with the permanence of the sulligs and yokes of the open field system, of which the family holdings were composed of, in which the family had rights. The surveys of Kentish manors in the records of Battle Abbey and the Black Book of St. Augustine present instances sometimes of sulligs and yokes held by the heredes of a deceased person and sometimes of others, which maintain their unity for purposes of payments and services, although in the possession of several holders. The sullig in these cases seems to have continued to be the unit liable for the fixed ploughing and other services irrespective of the question who were its occupants. Once more, perhaps some light may be gained from Cymric tribal custom. We have learned from the Cymric evidence that a district might be divided for purposes of revenue and food rents into sub-districts, irrespective of who might be the occupants. And we have seen also how the Cymric trefegald, or unit of pastoral occupation, with its one plough and one churn and one herd of cattle under a single herdsman, could remain a permanent taxable unit paying the tunk pound in lieu of food rents, whoever might at the time be its occupants and have cattle in the herd. Within the lines of tribal custom itself, the members of a Cymric Welly might be spread over a district and their cattle distributed among many trefgords, while, from the chieftain's point of view, the local units of taxation were uniform and regular. But this must not blind our eyes to the fact that the yardlands on Anglo-Saxon estates were, so far as we can see, for the most part really individual holdings with actual single succession. However hard tribal custom may have fought for the family element, the manorial element in the end seems to have prevailed on most manors so as to secure, for the purposes of the lordship and the convenience of manorial management, single succession to the yardlands. The fact that as early as King Inni's time, we see new individual holdings of gebers being made by the allotment of yardlands and homesteads to individual tenants in return for gavel and work, when taken in connection with the rectitudines, brings us back to the likeness of these holdings to the holdings of the Villani of later times. We see in the allotment of stock to the geber, of which we trace scattered evidence, the fact on which the principle of the later villanage was based. Only when both homestead and yardland came from the lord was there to be work as well as gavel under King Inni's laws. The stock of the holding, according to the rectitudines, belonged in theory to the lord and upon the tenant's death returned to the lord. The continuance to another tenant on the payment of a relief involved the admission that the holding and its outfit were a loan from the lord. The fact that in exceptional cases family holdings were able to maintain their own under manorial management must not be allowed to lead us to underrate the power of the manorial element. They were in tribal custom itself, as described by Tacitus, elements of what we have elsewhere spoken of as the embryo manor. But this must not blind our eyes to the fact that something more was required to produce the general uniformity of holdings and single succession upon manorial estates than tribal custom working alone. If, from a tribal point of view, we try to understand the growth of manorial serfdom and see how on the continent it was seemingly the result of the combination of two leading factors, tribal custom and Roman methods of land management, it becomes hardly possible to ignore the presence of something like the same combination of two interacting factors on British or English ground. With the manorial side of serfdom in its connection with the widely prevalent open field system, we have already attempted to deal in a form of volume. That there may have been some continuity and continuance of estates managed on the Roman system can hardly be denied. However far the policy of extermination of the old inhabitants was carried, it never extended over the whole area, and the whole of Britain was not conquered in the same century. Even if the continuity of estates in Britain should be considered to have been entirely broken by the Anglo-Saxon invasions, which is hardly conceivable, it must be admitted that continuity and likeness between England and the continent, as to land management, was very soon restored on monastic and other ecclesiastical estates, and perhaps also on what was royal domain. Nor can it be doubted that herein was a force greatly strengthening the manorial element. If we limit our view to the tribal side only of the problem, we recognize that in Scandinavia and in the Cymric districts of our own island and in Ireland, tribal principles working alone tended powerfully, without help from the Roman side, to produce a class of tenants becoming Cbteddy after 4 generations of occupation, but it did not produce either in Norway or in Wales or Ireland or in Celtic Scotland that general and typical form of occupation in uniform yardlands or huben, so prevalent in England and Germany on manorial estates, with ostensibly single succession and services in so many points resembling those of the Roman colonate. Whether the manor was the indirect or direct successor of the Roman via, i.e., whether the continuity was broken or not, the manorial use of the open field system of agriculture seems to be required to produce the uniformity of holdings in yardlands and the single succession which marked what is roughly called the serfdom of the manorial estate. It is hardly necessary to repeat that the open field system itself was not of manorial origin. It was essentially an economic result and differed very greatly in its form. Its main object seems to have been fairness and equality of occupation. Under tribal custom in Wales, it arose out of correlation of portions of the waste or pasture by the common plough team to which the tribesmen or the teogs, as the case might be, contributed oxen. The strips were day works of the plough taken in rotation by the contributors according to the place of their oxen in the plough team for the season, and they returned into common pasture when the crop had been removed. The tribesman in the pastoral stage was the owner of oxen, but not of the strips ploughed by them. They were merged again in the common pasture of the district in which he had rights of grazing for his cattle, and the cattle, and not the corn crops, were the main thing upon which the system turned. Whatever method of distribution may have been followed, as arable farming increased and the strips became more and more permanently arable, mostly on the 2-field or the 3-field system, the area of unplowed land was more and more restricted, and the pasture over the stubbles and fallows obviously became more and more essential. The cattle, on the one hand, required the pasture on the stubbles and fallows, and the land, before being plowed again, required the manure arising from the pasturing of the flocks and herds upon it. Where open field husbandry still exists in Western Europe, whether on this or the other side of the Channel, the owner of the strips has still no right of grazing upon his own strips, till upon the appointed day when the common right begins of all the holders to graze their cattle in a common herd or flock over the whole area. This right is known in France as the vin pâture, and it is still the most important and indestructible element in the open field husbandry. In the great open fields around Chartres, a man may plant his strips with vines if he likes, but to this day, if he does so, he must let the sheep of the commune graze over them after a certain date, in exercise of the immemorial right of the vin pâture. In all this, no manorial element need be present. And when the manorial element is absent, there is not necessarily any uniformity or single succession in the holdings. But when manorial management comes upon the top of this widely extended and all but universal system of agriculture, whether in Roman times or later, the bundle of scattered strips which under tribal custom could be plowed by a pair of oxen, whether alone or in joint plowing, is very naturally taken as the typical holding. And thus we find in the laws of any and later records, gaffel-gelders and gevers settled upon yardlands and doing service by week work on the lord's demesnes. The natural inference must be that it is the result of manorial land management, and that there has come into existence already something like a manor with something like a community in serfdom upon it, using the prevalent open field system as the shell in which it will henceforth live so far as its agriculture is concerned. And so it seems natural to attribute to the manorial management and the manorial requirement of fixed services and dues the uniformity of the holdings and the single succession by which the uniformity was preserved. The power which seeks and makes uniformity seems to come from above. Agricultural communities of free tribesmen who had become individual freeholders, if such could be conceived of as prevalent in King Inni's and King Alfred's time, would probably have used the open field system in a quite different way, and we see no trace of it in the evidence. When, however, we have said this, we have no disposition to ignore or make light of the matter, evidence upon which great stress has quite rightly been laid by Professor Maitland in his remarkable work on the Doomsday Survey and beyond, showing that there were in some districts villages in which the manorial element was apparently absent in the time of Edward the Confessor, though appearing as manors after the conquest. He has suggested that in these villages not only the manor in name, but also the manor as a thing, was apparently non-existent. There was in these cases apparently, in King Edward's time, no demesne land upon which the services of a tenantry in villanage could be rendered, and the tenants were often sokemen, who had individually put themselves under the protection of this lord or that, instead of there being one lordship over the group as in a manor. These lordless villages on the eve of the conquest, as shown by the entries TRE in the Doomsday Survey and especially in the Inquisito Elienus, merit more careful study than has yet been given to them, and so far as they can be shown to prove the existence of free villages of liberi hominis or sacomeni, after the conquest, merged sometimes in the class of villainy. I am ready to welcome the evidence, but unless they can be traced back to earlier times, their occurrence mostly in the Danish districts, interspersed with other villages which were manors and had demesne land, together with the singular fact that the holders in these villages were commended to several lords, suggests that their peculiar position may date from the time of Danish invasions, and be the result of the devastations as to the effects of which the Liber Elienus contains so much evidence. Many a manor may have lost both lord and tenants, and have been filled up again by the great lords of the district with new tenants, soldiers and servants who had served in the wars, it may be. Thus, these cases in which many features of the ordinary manor were apparently missing in the time of Edward the Confessor may be of recent date and so, while important when viewed in relation to the Doomsday Survey and the changes made by the conquest, not specially instructive as regards either Anglo-Saxon conditions. Unfortunately, as we have seen, the laws of the Danish period, while recording existing and modified Anglo-Saxon customs on various points, leave us in the dark as to Danish custom, whether of old standing in the Danelaga or newly imported in King Canut's time. It was, no doubt, known to the invaders, and it was enough for them to say, as the law stands, though we do not know what it was. The whole question of the Danelaga was purposely omitted from the scope of my former volume, and now, after 20 years, still remains a subject requiring careful examination by future inquirers. But this cannot be done completely until the minute work which Professor Maitland and Mr. Round and Mr. Corbett are gradually doing upon the Doomsday Survey itself, in its local details, has been further pursued, and it lies, with so many other branches of a difficult subject, beyond the limits of inquiry made in this volume. Reference may, however, be incidentally made to the numerous cases in which, in order to describe the nature of the tenure of Sakmani and others, under what were perhaps new conditions, the fact was recorded in varying phrases whether this person or that, or could not leave or sell his land. Of some it is stated posset reseteri, of others non-posset reseteri, of some posset venderi, of others non-posset venderi. Though these tenures may have been comparatively modern and may belong to a period of advanced feudal conditions, still it may be possible that some trait of tribal custom may lurk at the root of the distinction. From the manorial point of view, it was necessary to record the Sakmani, whether they had only limited rights in the land, subject to the performance of services and constitutinies, which, by the way, seem to have been very much like those of the Villani, or whether they were permanent freeholders who could sell their holdings and leave the land when they liked. The position of the tenants in this respect was probably dependent upon the tenure upon which they held, i.e., upon whether they were tenants with only life interests, or for successive lives, or, as we should say, tenants in fee. After the devastations of war, many new tenants must have been put upon desolated manors, and Professor Maitland has very rightly laid stress in another connection on the traditional habit of granting leases for 3 lives only, so that a holding might ultimately return to the Lord. He has pointed out that when Bishop Oswald, A.D. 962 to 992, exercising manorial rights over the great domain of the Church of Worcester, made these leases to thanes on certain services for 3 consecutive lives, i.e., for the lives of father, son, and grandson. He did it expressly for the purpose of securing to his successor full power to renew them or not. And from a tribal point of view, it may be a pertinent question whether the restriction to the 3 generations had not some indirect connection with the tribal custom or instinct, so often alluded to, which gave to the 4th generation of uninterrupted occupation fixity of tenure and status. Recurring to the scattered cases of thanes holding in Paragio, and by no means confined to the Danish districts, it was necessary to state in the Doomsday records, as in the case of the Sakmani, whether they had or had not power to leave or to sell. And it may be useful that we should be reminded by these cases in which feudal custom had possibly arisen out of tribal custom, that tribal custom was not unknown to the Danish and Norman conquerors of England. The Danish immigrants came from a district in which tribal custom was still fresh and vigorous. The Normans, too, as is shown by the so-called laws of Henry I, found Anglo-Saxon custom by no means altogether alien to their own instincts. Before concluding this essay, perhaps a further observation should be made. We have learned in the course of this inquiry that it does not do to take too insular a view of Anglo-Saxon conditions. The similarity of Virgils, and indeed of tribal custom generally, has throughout become very apparent. Perhaps it is hardly more striking than the similarity in the modifications of tribal custom found in the laws on both sides of the Channel. In their migrations and conquests, the conquering tribes found themselves everywhere, breathing a moral atmosphere in which it was difficult for the old tribal instincts to live. In such matters as the responsibility of a master for his slaves' homicides and of relatives for their kinsmen's crimes, we have watched, as it were, modifications of tribal custom in the course of being made here and there, or almost identical lines. May it not have also been so also in regard to the important matter of the division of classes? If we have recognized rightly the tribal principles originally at the root of distinction between the 12 Hind and the Tri-Hind classes, there is no reason why we should not recognize also that besides the potent force of manorial management, there may have been other influences at work, widening the gulf between the two classes, and, so to speak, reducing to a level the members of each class by breaking away the rungs of the ladder between them. It must not be overlooked that in the earliest continental laws, most nearly contemporary with those of Kent, Alemannic, Bavarian, Burgundian, and Visigothic, the divisions of society have a very artificial look, as though largely based upon wealth rather than the tribal principles of kindred. Now, German writers have not agreed upon the point whether these artificial divisions found in these earliest of the laws ought to be regarded as belonging to ancient German custom, or whether they may not rather be traced to Roman influences. We have already seen how necessary it is in connection with these early laws to discriminate between ancient custom and the new influences which were working in them in the direction of individualism and the disintegration of the kindred. The earliest laws are, as we have seen, just those in which tribal custom had fared the worst. In the Alemannic practice of the 6th century, the grades for Vergels were as under: 1. Baro de Beneficis, 2. Medianus Alemanus, 3. Primus or Melioramus Alemanus. And these were the subdivisions of the ingenuous class, for they were below them the lightest and the service. In another clause, a similar division is applied to animals. The penalties are given for killing ordinary, mediana, and meliosama jubenta. In the Burgundian laws, the division of society into 3 grades, optimates, mediocres, and inferiores, is found in the Lex Romana and is applied to Romans and Burgundians alike. These divisions seem to supplant those of kindred and to have no tribal principle at their root. In the Visigothic laws, the disintegration of tribal society is so far advanced that the Vergels of the ingenuous class are regulated, not by kindred or social position, but, as we have seen, according to the age of the individual. It is difficult not to connect the substitution of artificial grades for those dependent on kindred with the Roman tendency to divide society into patrician and plebs, and the plebs, according to position and wealth, into homostorius and humiliores. Already in Caesar's time we have seen how difficult it was, from a Roman point of view, to understand the relation under tribal custom of the dependent tribesmen to their chieftain. Caesar does not seem to have recognized the link of blood relationship between them. To his view, the chieftains were equites, and the tribesmen almost their servi. It was difficult otherwise to bring the two classes within some recognized category of Roman law. So it was, no doubt, in degree, at the later period in the case of the conquering German tribes, when the Romanizing forces were mainly in clerical hands. The influence of the Church also holds in favor of the artificial and anti-tribal division of the people into great men and small men. Its tenets of individual responsibility favored individualism. Canon 16 of the Council of Orleans, A.D. 549, shows that the ecclesiastical mind in Gaul was familiar with the division into classes majorum et mediocrum personarum. A canon of an earlier council, A.D. 511, shows how by taking refuge in a church, a homicide received protection till composition was arranged, and how thus the question of Vergels was brought within clerical recognition. Once brought within its power, the Church was not likely to let it slip from its grasp, and the collections of formulae of the Merovingian period show how the clergy joined with the other authorities in arranging the payment of Vergels and the prevention of private vengeance. From these formulae, it would seem that the payment and perhaps the amount of the Vergeld had become to some extent a matter of mediation and arrangement through the intervention of body homines, who were sometimes sacerdotes. And when the award was given and the payment made, it was natural that a formal charter of acknowledgement and stay of vengeance on the part of the relations of the slain should be insisted upon. Each set of formulae contains a form for this purpose. The matter of Vergels has become a subject of Franco-Roman conveyancing. Romanizing and clerical influences thus working together in connection with Vergels, would naturally tend to exclude from consideration the question of kindred and to make the payment of the vergeld a matter for the homicide alone. Long before the time of King Ini, these Romanizing influences must have been at work in England, as elsewhere, introducing new considerations of justice and the position of classes founded on Roman law and Christian feeling, and not upon tribal custom. We have recognized some such action as this in the nearly contemporary canons and in the Kentish laws, as well as in the later Anglo-Saxon laws, and indeed again and again throughout this inquiry, so that while we have had to notice again and again the extent to which the Church succumbed to tribal custom when it suited its purpose to do so, it must not be forgotten how much of the modification of custom found in the laws was due to the influence of the Romanized Church. It is not therefore enough to recognize only Romanized forms of land management under clerical influence. We must recognize also something of the same persistent antagonism of the Church to tribal custom, which on the continent had already in the 6th and 7th centuries sometimes succeeded in extruding considerations of kindred from the matter of vergels, and to a great extent also from the question of the division of classes. With this further recognition of outside influences, this contribution toward the understanding of a difficult question must come to an end. All that can be claimed on its behalf is that a few further steps in advance may have been made good. It may have seemed to have resulted rather in a restatement of some of the problems than in their solution. But this is what might be expected from the attempt to approach a subject which has many sides, especially with light from the tribal side only. Following the true method of working from the known to the unknown, it is not until such a problem has been approached separately from its different sides that a final solution can be reached, and this involves the fellow work of many historical students. In the meantime, without ignoring or seeking to minimize the force of other important influences, it may, I think, safely be said that we have found the influence of tribal custom upon Anglo-Saxon polity and economic conditions as apparent, all things considered, as there could be reason to expect. It was a factor in economic development which, among others and in due proportion, has to be reckoned with, and its study has the special value that it helps to bring the student of the Anglo-Saxon laws to regard them from the point of view of the Anglo-Saxon settlers themselves. End of section 37. End of Tribal Custom in Anglo-Saxon Law by Frederic Seebohm.